Good morning, everybody. This is the January Commission meeting of the OLCC, and let's take the roll.
Commissioner Curran is absent. Turn this on. Commissioner Curran is delayed. Commissioner Harper?
Here.
Commissioner Miletus?
Here.
Commissioner Revolt?
Here.
Chairman Rosenbaum?
Here. So we have a quorum. And first, what time do we expect the commissioner?
I think about
10 o'clock? Okay. Her plane is delayed. So the first item on the agenda is the contested case hearings in the Trio Club. Michael, are you ready to go, counsel?
Yes, Mr. Chairman, we are ready.
Is it ready, willing, and able?
Ready, willing, and able, yes, sir. Yes, Chairman. So, just for your information, Chair Rosenbaum, is this on? Yep. Chair Rosenbaum, members of the commission, good morning, I'm Michael Shine from AP&P, and joining me is Ryan Kroll, who is counsel, seated at the end table there for Trio Club. Good morning. And Sammy Fong, president and stockholder of Trio Club, which is does business at 909 East Burnside in Portland. This is a liquor compliance action that was signed by Director Marks and mailed out exactly 1 year ago today. Before you for approval is Senior Administrative Law Judge Rackstraw's proposed order, a 58-page opinion in which she recommends cancellation of this full on-premises liquor license. I'm going to present the commission's case, then turn things over to Mr. Kroll to argue his client's exceptions to the proposed order of cancellation, after which I will ask for a chance to respond to Mr. Kroll very briefly before you retire to deliberate. We will confine our remarks to the evidence of record and to the exceptions and comments filed, and we will each try to limit our remarks to about 10 to 15 minutes. Back on June 15, 2016, the Commission issued Trio Club a notice of warning and demand for an enforceable compliance plan based on a history of serious and persistent problems that Commission staff determined to be present at the premises. Licensee Sammy Fong signed the enforceable compliance plan, and it went into effect July 20, 2016. The purpose of such enforceable compliance plans, or ECPs as we call them, is to prevent future incidents of disorder from occurring at the premises. Unfortunately, that did not happen here. In the present new case, we charged a history of serious and persistent problems based on 37 alleged incidents over a 30-month period from October 30, 2015 to April 1, 2018. Under the Commission's penalty schedule, this is a Category 1 violation with a presumptive penalty of license cancellation. In addition, the notice charged 5 counts of permitting disorder, 2 violations of the ECP, and a claim of failure to evict patrons. This matter was heard before Administrative Law Judge Rackstraw June 11, 12, 13, 14, and 22 of 2018. 32 witnesses testified. These witnesses included the licensee, Mr. Fong, his manager, Suzanne Fong, his son, Zach Fong, who all got to tell their version of the events in question, as well as OLCC Inspectors Scott Pitton and David Luster, OLCC Statewide Public Safety and Liquor Compliance Technician, Siobhan Triska, and 21 members of the Portland Police Bureau, from Gang Enforcement Team Sergeant down to rank-and-file entertainment detail officers who come into contact with dozens of OLCC licensed premises on a daily basis. Based on all that evidence, plus substantial written briefing filed by Mr. Kroll and myself, Judge Rackstraw found 25 proven disturbances in a 30-month period at or in the immediate vicinity of the Trio Club that involved violence or threats of violence, plus 1 violation of a no-contact order that club security failed to enforce, plus 3 less serious property crimes inside the premises. And that's proposed order at page 38. Significantly, 20 of these incidents occurred after the date that ECP went into effect back in July of 2016, showing that despite being given a warning and a chance to enforce a specific plan to quell disorder, this licensee lacked the willingness or the ability to do so. Now I want to talk a little bit about the number of incidents. Commission staff argued after the hearing that we had proven 34 serious incidents. After tough litigation defended by a capable attorney, the judge found 25 incidents in 30 months. Commission staff in comments before you seeks to add 3 serious violence and 1 less serious public intoxication incident, so there would be 28 serious incidents. But let's put these numbers in context. To quote Judge Rackstraw's proposed order at page 38, quote, OLCC Inspector Pitton observed during his 1.5 years assigned to that geographic area that Trio Club had more physical altercations, more incidences of highly intoxicated patrons, and more need for police involvement than other licensed premises in the area. Moreover, PPB, Portland Police Bureau Sergeant Simon, who worked in the Central Precinct Entertainment Detail from 2014 to 2017, opined that Trio Club had more incidents of disorder than just about anyone in Central Precinct. So Trio Club has long been recognized by both OLCC and Portland Police as a particular problem premises. In addition, on December 26, 2017, after issuing 4 nuisance warning letters to Trio Club in under 2 years, the City of Portland recommended to the Commission not to renew Trio Club's license. Now, my opponent, Mr. Kroll, will try to get you to shave a few incidents off of the findings. As a general matter, you should not do so because the isolated and happenstance incidents to which he refers in his briefing were already discarded by Judge Rackstraw. Either way, this case merits finding of a history of serious and persistent problems. And I quote from this Commission's decision in Shenanigans Irish Pub, 11V 065 from 2012, quote, in other cases, the Commission has found a history of serious and persistent problems where there were significantly fewer problems at the licensed premises. See Balzer's Pub and Grill, 5 serious incidents within 6 months constitutes a history of serious and persistent problems. A Rastafarian Private Club, 8 serious incidents during a 1-year period. And Headless Horseman, 7 serious incidents within 13 months. And of course, a history case isn't just about numbers. Here, incidents included large intoxicated crowds of upwards of 100 to 200 people who were spilling into the streets, blocking and forcing closure of East Burnside, and fighting in streets in East Burnside, which of course is a major thoroughfare, thereby threatening public safety both directly and by draining limited police resources. And then the latest incident, the last one in this history case, April 1, 2018, was frankly terrible. It included excessive force against a highly intoxicated patron by Trio Club security staff and by licensee himself, including the licensee personally, who in finding of fact 68, quote, twice stomped on the patron's torso with his foot, and then the licensee's son, former bar manager, Zach Fong, spitting on the patron while he was being held down on the sidewalk by security. They both denied this in testimony, but video evidence and their security staff testimony showed otherwise. Now I'd like to turn our attention to the question of willingness and ability to control the premises. Once a history case has been shown, licensee has the burden of proving it has the willingness and the ability, not just the willingness, but the willingness and the ability to control the premises as a way to mitigate the penalty possibly from cancellation to license restrictions and a possible fine or suspension. That burden is not just to show, I want to stress this, that they want to fix things, but also that they actually can fix things. Here it's clear that Sammy Fong, even if it's not even clear he really has the willingness in light of his actions, which I would argue speak louder than any words, from the most recent proven event. But it's very clear that it's crystal clear that he does not have the ability to control Trio Club. Mr. Kroll may discuss a list of proposed, quote, restrictions that Trio Club offered into evidence that it would like as license restrictions. Just so you know, those restrictions were not drafted by, offered, or approved by Commission staff. After the failed ECP, Commission staff does not believe restrictions can quell disorder at the Trio Club. Mr. Kroll will discuss control measures that are already put in place at Trio Club. Judge Rackstraw considered all those and rejected them. She was correct that many of the so-called control measures you'll hear about from Mr. Kroll, enforcing a dress code, using an ID scanner at the door to retain patron images, charging higher admission prices, having no happy hour or discounted drinks, and implementing a slow close, have been in place since 2015 or 2016 and have not effectively prevented the 25 to 28 serious incidents that make up this history case. In addition, the 20 serious violent incidents proven to have occurred after implementation of the ECP are strong evidence of lack of willingness and ability. And second, licensee's own behavior suggests that he is not capable of reasonable compliance with OLCC rules, of setting a good example for his staff to follow, or that he can be a reliable partner for the OLCC and police to work with. Trio Club's principal witness for the alleged effectiveness of their efforts to control disorder, club manager Suzanne Fong, testified that she had been trying her best to control the premises and the patrons at Trio Club since 2015 and 2016. The evidence of 25 to 28 serious violent incidents in 30 months, even after club management began trying their best to control the premises, demonstrates by a preponderance of the evidence that licensee lacks the willingness and ability to control the premises. Now, I want to briefly move from the history charge, because that was not the only charge here, to the other violations that were found by Judge Rackstraw and that we ask that this commission find. In addition to the history charge, Judge Rackstraw also found 4 out of the 5 charges of permitting disorder. First, on May 1, 2017, when Trio Club security had knowledge of a patron fight inside the premises, but refused to answer police officers' questions about what was going on, and they were further unable to control the ongoing disorder. Second, on July 1, 2017, when Trio Club security were taking no steps to control large intoxicated crowds estimated by police at 100 to 200 persons, blocking sidewalks and fighting in the streets. A third, on October 22, 2017, when Trio Club security ejected 3 patrons involved in a fight inside the premises in such a manner that they simply moved the fight from inside the premises to the adjoining streets, and then security failed to control patrons who spilled from the club to join in the fighting, such that there were then 3 active fights going on various streets around the club when the police arrived. Fourth, on April 1, 2018, when security and licensee personally used excessive force to subdue an intoxicated patron who had been involved in a fight inside the club, and that's the incident I previously referred to. And in addition, on several occasions when Trio Club's head of security was able to calm the patron, then licensee Sammy Fong got in his face, if you will, and provoked him into further resistance, thus prolonging the excessive force and exacerbating the disorder. In addition, the following charges were proven. In addition to the permitting disorder charges, there's 4 of those. And there are 2 violations of the ECP. One on May 21, 2017, paragraph 2 of the enforceable compliance plan limited the amount that could be served to a patron at any given time, and one of the limitations was 6 ounces of wine. A Portland Police Bureau officer entered the club and saw a patron drinking directly from a champagne bottle, which was, and the fact that they did serve champagne bottles directly to their patrons who paid a VIP price for a special table was admitted to our inspector, and our inspector testified to that at a meeting at the premises a couple days after this incident. Second, a violation of the ECP provision requiring installation of a new video surveillance system and training, importantly, training of the staff so they knew how to produce and supply video footage to the OLCC upon request. And in this case, General Manager Suzanne Fong was not trained to produce video. A video was requested by Inspector Pitton in May of 2017. The request was reiterated several times, and it dragged out over a month before before General Manager Suzanne Fong admitted that she was no longer able to produce the video. So those violations of the ECP were found by Judge Rackstraw. Judge Rackstraw found that cancellation was therefore warranted, both for the history, Cat 1, and secondly, because there was a finding of 6 Category 3 violations within 2 years at this premises, and under this Commission's guidelines, 4 or more. Cat 3s within 2 years constitute a cancelable offense. It was also cancelable under OAR 845-006-0508EL, which provides that when there are 3 or more violations of any category at a premises within a 2-year period, which indicate disregard for law or failure to control the premises, that's grounds for this commission to cancel the license. Judge Rackstraw specifically found in this case that licensee was unable to adequately control the premises within the meaning of this rule. So staff requests that the commission adopt the corrected proposed order as modified by staff comments as the commission final order in this matter. I'll save any remaining very brief response to Mr. Kroll when he is finished, or to answer any questions you may have. Thank you.
Thank you.
Good morning, Chairman, Commissioners. My name is Ryan Kroll, and I represent Trio Club. To my right is Mr. Fung, who I'll refer to as Sammy, because basically everyone else does. And I apologize, I am under the weather, so if at any point I'm hard to hear or understand, please just let me know. I am trying my best here. What I want to do, though, is every story has 2 sides to it. And so what I want to address is the other side to this story. And in my focus initially, I want to address the 2 parts of a serious and persistent allegation, a history of serious and persistent incidents. And what was really focused on by the commission was the history, the incidents. And I'm not going to delve into those. What I really want to address the attention to is the second part, the latter part of you can have a history of serious and persistent events, but still establish mitigation after the fact to show that cancellation is not the appropriate penalty. And that's exactly what I feel here in this instance. Now, we have the written exceptions to the incidents. I'm not going to address those. What I want to talk about is what this licensee has done and the dramatic change that has occurred at this location since these changes. Now, to give a little bit of a background, Sammy, this is not the one license he has. He's operated and owned the Ambassador since 1990, another OLCC license premises, and another location during the 90s as well. So he's not new to this sort of business. And in each of the 2 or 3 prior businesses he had, there was always some sort of instances initially that there were problems at the location. And what Sammy did, and with his help of his then wife, who's now his general manager, is they made changes and corrections along the way. They found that increasing cover charge helped. They found adding security helped. They constantly tweaked their business model to it got to a point that they were no longer having these problems. And the ambassador has been in Portland since 1990. It hasn't had any issues probably since 92, 93, and it's still running today without any problems. And that was the same sort of mindset they brought to Trio, is that they began operating it, there were problems there, but they were constantly doing changes. If there were suggestions by the police to buy a high-tech, state-of-the-art security system, they did it. I mean, what they have there is remarkable. It's almost similar, I think, to what casinos have, where someone comes in, scans an ID, they keep the photo of the ID, and they keep a photo of that person in their memory bank. And the reason the police had asked for that said, hey, if there's incidents, we want to be able to track these people. So now every single person that comes into Trio has their photo taken, has their name identified on identification, so there can't be an incident that occurs without knowing exactly who that person is. Now this is at the expense of Trio. They weren't required to do it, they did it. They made constant changes throughout. And as Mr. Shine pointed out, those didn't always work. But what did start working and where I want to focus is the latter part of 2017. Because if you look at all the evidence that was submitted, and it was a long trial, and I know there's a lot of evidence, but at the end of 2017, there were some real dramatic changes that happened. And the net effect of that is that beginning January 1 up to the date of the hearing in June 11th, during that 5-month span, 5.5-month span, there was only one incident. Just one. Now that's a dramatic change from what was happening before, and that's when I talk about willingness and then ability to control the premises. That's what's being demonstrated. Now prior commission decisions, such as Girdle's Restaurants, which is 08V as in Victor 079, in that case, this commission found that a location that had a history of serious problems, but then went through a several months period without any, but then had subsequent ones. And they actually had a couple problems, about 3 or 4. In that instance, because of that change during that time period over those months, where it dropped down from a high frequency to a low frequency, this commission found that that was mitigation, that was a demonstration of a willingness and an ability to control the premises. And so the standard that was applied in the proposed decision by the ALJ is incorrect. The reason she dismissed all these great changes in late 17 was because there was one incident on April 1st, 2018. And the position taken in the proposed order is you can't have because that one incident happened, you don't have the ability. Well, that's not the law, and that's not the precedent of this commission. This commission has found locations that even had several problems after the charging document came out. But because they had several months of no problems and then a less frequency, in that Girdle's case, Girdle's Restaurant, that was found to be mitigation, and cancellation was not the appropriate penalty. And that's very important here. And so the proposed order is wrong on the law. That one incident, although we dispute that incident is really an incident, and the written exceptions go into detail about that, but assume that it is. That's one instance in 5.5 months. That's a dramatic change. We wouldn't be here, there wouldn't be a charging document for one instance in 5.5 months. And that's the change that occurred because of proactive steps taken by the licensee. And these steps were taken in late 2017 before the charging document came out. So this was not a response to, oh no, we're in trouble, let's make the changes. These were things they were doing on their own volition because they cared about the location, and they were getting to a point where they are now of they're not a bad operator, they are a good operator. It took them time. That's the business reality, there's no magic bullet. If there was, OLCC would just tell Sammy, do this one thing or do these 3 things, you'll have no problem. No one told him that because no one knows the answer. The business reality is that you're trying to make these changes throughout, and as someone that's using the business as their livelihood, yeah, you don't always make every change right off the bat because you don't know how it's going to affect your business, and you don't know if you'll be able to provide for yourself and your family. So you make these changes throughout and constantly. But that dedication to changing is demonstrated in the evidence. And the changes that they made in late 2017, which ultimately combined were basically the magic bullet, were this, is that there was a lot of furniture near the main bar. And because of that, that compacted the space. And so what they found is that there was fights or agitation occurring because people were bumping into each other by the main bar. So they took out the seating to make the walkway wider. Simple change, not something that anyone told them to do, but that actually helped alleviate a lot of problems because it gave more space. Another thing they did, and it's demonstrated in Exhibit R11, is they bought a TSA level metal detector. And this thing is out in front of the Trio Club on 9th and Burnside. And I've seen it. I mean, it's imposing. It serves two factors. One is to prevent metal, and realistically, there's no evidence in here of any guns or knives or none of that is occurring inside the location. But it's a statement. It's a statement to anyone trying to enter this premises that, hey, they went through the effort, and people don't know it, but it was in the evidence that they spent about $4,000 or $5,000 on this thing. It's a statement of, we're a no-nonsense place. Don't come here to bring your fights. Don't come here to bring the troubles you have outside. We're here to operate our business, and it's an imposing stature that's right in front of the club. And that helped make a dramatic change. They also increased their cover charge, which, as a business, you don't know how that's going to impact you. There was arguments from the OLCC that, well, that means you make more money. Well, not necessarily. I mean, if they had known if they make more money, they would have been doing it earlier. You don't know when you start driving people away. So they constantly increase their cover charge with the idea that people aren't going to pay now $15, $20 and get kicked out for a fight. You know, you're just attracting a different type of people, and you're attracting people that have a different want for the evening rather than to bring their problems from the outside in. Another thing they did, which was, I think, really helpful, was they stopped using promoters. And so they stopped using promoters. They no longer gave away the control over who's coming into their location. And that they really focused on trying to create what's called regulars, people that come here frequently. Now this has now turned into a dance club that has people from 21 up to in their 60s. And because people are regulars, they know Sammy, they know Suzanne. You know, if they have a problem, they know to come talk to them rather than start a fight. And they also have a vested interest because this is now turning into their community. And so this premises is really operating much differently than it was in 15, 16, 17, because the clientele is now their regulars, their people that they want. And the other change that occurred in 2018 is they switched to an in-house security team. The benefit from this is that when you have outside security, you can't control who's there. You hire the company, and then they provide 8 people. And you don't get the same people week in, week out. So these people don't know the crowd. They don't know Sammy. They don't know what to expect. And so we don't have people week in, week out. They just don't know the business. By having an in-house security team, Sammy was able to have someone lead that, and these employees are then there every weekend, and they know the customers, and they know Sammy, they know the business protocols, they know what they're supposed to do. And that's made a dramatic change too. And all these changes were done on the own volition of the licensee. They're just constantly trying to get better and better. And another point of this is that unlike some businesses where you have the owner just owns it, gives it to a GM, lets him run it, Sammy was there every Friday, Saturday, Sunday night when these problems were happening. His ex-wife was there Suzanne, every Friday, Saturday, Sunday night. His son was there for part of this period, Friday, Saturday, Sunday nights. So not only is it not a good business idea to have a problem place, but they were personally there. His ex-wife, who he's still very close with, was there. His son, who's still very, his son, was there. He's very vested in this business. He's a very hands-on owner, and he was constantly trying to get it to the point where it is now. So with that in mind, and the prior precedent of the OLCC, I do think that it has been established that regardless of the history of serious events beforehand, assuming that's found, that he does have a willingness and ability to control the premises. And the ALJ was just wrong in how she applied the law to say because you have one instance, post-charging document, you don't have that willingness and ability. That's not what prior precedent from this commission says, and that's not the law. And I think that this has been established. And additionally, this same argument applies to, as pointed out, we're not just here for a history of serious and persistent problems, we're here for other violations. But it applies to those violations too, where the ALJ found that there was no mitigation. Well, there was mitigation. This is the mitigation that we were talking about. And this place in 2018 up through now doesn't operate like it did before. And that is really what the statute was it 473.315, is talking about when it expressly allows, statute says, you can have this mitigation of a willingness and ability. And the concept that you can't, the concept that the judge kind of puts forth that, well, you don't have an ability if you have a problem, you know, post-problem, it's not reflective of realities. The other part that we argued, and I think does show a willingness and ability, was the proposed restrictions. Now, there's precedent for this as well, is that in the case of Don's Dugout, OLCC 12-V as in Victor 065, in that instance, it was found that despite the location having a history of serious and persistent problems, subsequent to the charging notice, the licensee implemented a control plan that had all these new restrictions on there. And based upon that, it was found that that was mitigation. And so what Mr. Fung had done, what Sammy had done, was not only made all the changes that he made anyway, but on top of that, had some very serious restrictions that he was willing to be imposed in lieu of cancellation. And these included, you know, stopping the sale of alcohol at 1 a.m. And that time period is not just picked out of thin air, is that we went through all the instances, and there was only, I think, a handful that had ever occurred prior to 1 a.m. And so if the commission's decision is to still cancel despite demonstrating a willingness and ability to control the premises, then we suggested these restrictions. I mean, at the end of the day, I think this licensee has done enough to not have their license canceled today. They have demonstrated this ability. They are hands-on. They have made changes throughout, and they started having success. It's an unfortunate timing, but the success began right after the charging document. But that was only because they constantly tried to do this. And so I think at the end of the day today, cancellation is not appropriate. If mitigation on itself is not shown, then impose the restrictions. But this licensee has earned that chance, I think. They operate other locations without problem. They have tried, and they have been successful, finally, at this location. Cancellation is not warranted. And moving on, I do want to address the permitting the disorderly. There's 4 of those. And again, I think I'm not going to argue the facts, as there is 4.5 days or 5 days of the testimony. There's a lot there. But it's just a simple matter of law that I think the judge got it wrong in the proposed order. This commission previously has held that for a violation of OAR 845-006-0347-2A, which is a violation for permitting a disorderly conduct. Now, it's not a strict liability regulation. It doesn't say, oh, because there was a disorderly conduct, you're in trouble. That's not the law, and that's not the way it's written. That's not the way it's been interpreted by this commission. How it's been interpreted by this commission, what was intended is a licensee cannot watch some disturbance happening and not do anything. And there's instances in the prior decisions where someone was watching someone get in a fight and did nothing, sat back. That's the violation of this regulation. What this commission has held previously, in one case, In re Gruska, Gruska, OLCC, I guess I have the wrong number there, but it's cited in the exceptions, is that in order to prove this violation, the commission has held, and this is a quote, that a violation of this nature occurs when a service permittee does nothing to intervene in a fight and does not call the police. And that was citing to a previous decision, which was the Red Garter Family Pizza, which was case number 88V as in Victor 057. So for 30 years now, this commission has held that this regulation, the commission has to prove that you didn't intervene and you didn't call the cops. What that means, though, is that if you did try to intervene or you called the cops, you're not violating this regulation because you were trying to do something about it. And the fact that whatever you tried didn't ultimately prevent it is not the violation. The violation is doing nothing. So when you look at these 4 conclusions of law, which is numbers 3, 6, 10, and 11, in each of these, it's clearly established, and actually the proposed order states that, for instance, for number 3, which occurred on May 21st, 2017, the security officers for Trio were intervening in this. There was a fight that broke out inside, and security officers were separating the individuals and brought them outside. Did it happen like that the fight stopped? No. But did they intervene? Absolutely. So it can't be a violation because the rule is not that something happened, but you did nothing. They did something. They had security there, and security broke up this fight. Now, for the other three, if number 6, number 10, and 11, it's undisputed again that it was the licensee that called the police when these instances happened. That's sufficient under prior precedent to show that they did not permit the disorderly conduct. And that's the standard that should be applied, and that is not the standard that was applied in the proposed decision. So the fact that the police were called by the trio on these instances means there cannot be a violation of what was charged. And that's much different than whether it counts for a history of serious and persistent problems. I think that's where the confusion was, is that it's not strict liability for this type of violation. It is, did you do nothing? And if you did something, if you intervened or you called the police, then it is not a violation. So each of these 4 times, Trio did either intervene or call the police themselves. Finally, moving on to another issue, and I'm not going to address all of them. I do appreciate your time. I know there's some lengthy briefing here. Was conclusion of law 5B, and the reason I'm bringing this one up is this has to do with the condition that was in the ECP, and the condition states only that individuals must be trained. Some employees must be trained on how to provide a videotape to the OLCC. That's it. That's all it says. The proposed order didn't say Trio didn't do this training. What the proposed order did, and I think is patently unfair, is said, well, there's an implied requirement on this condition that you have to actually produce a video when asked. I don't think that's fair. If you want that condition, the OLCC is more than capable, very capable, of writing that in to your ECP. The notion of having implied conditions where it's not stated expressly what a licensee is supposed to do and not do, it's too subjective. What if ultimately if the licensee doesn't interpret this subjective decision the same as the ALJ, they're in violation? That's not fair. The OLCC knows how to write conditions. They know how to write restrictions. And I've dealt with these sort of negotiations before, and sometimes the wording is changed to avoid things such as that. One reason that's really important here is that we do take issue with finding of fact 46, where it was found that inherently that the video was created and then destroyed. That's wrong. There is no evidence to support that. No one had ever seen this video, and from what the licensee had testified, there was an error in the system. So the problem is the OLCC never demonstrated, never proved. There's no evidence that this video ever existed at one point. So how can a licensee get in trouble for not providing something that the OLCC never proved existed? I mean, Inspector Pitton was down at the location right the day after this happened. He never saw the video. No one ever saw this video. So you can't get a licensee in trouble for not doing something that is impossible to do. And that's the other part of this, is you also can't get them in trouble for someone's implied requirement within a condition. If a licensee has to follow something, it needs to be stated to them. That's just basic fairness. And that didn't happen here, and I think the proposed order is wrong on conclusion of law 5B. Finally, just to address, I'm going to do this hopefully very quickly, the 4 new instances that the OLCC would like added to the proposed order of the findings.
And these are the 4 instances after the April incident.
No. There are no instances at all after the April 1st, 2000 incident. That is undisputed.
Okay.
Between January 1, 2018 to the date of the hearing, June 11th, there is just one alleged incident, April 1st.
To clarify, in the allegations that were brought, there were no incidents after April 1, 2018. That doesn't mean other incidents didn't occur, but there's a certain practicality when you're setting a case for hearing and you just cut off making charges and go on to hear the case that you've charged.
Well,
so for purposes of this proceeding, what he's referring to are incidents that were included in the charge letter. They all fit between October 2015 and April 2018, and the incidents that Mr. Kroll is referring to are ones that are in that time frame from October 2015 to April 2018.
I understand that.
Okay.
The argument that council's making, and he's doing an excellent job on it, in my opinion, he's handling it very well, is he's saying that, okay, in the past, all this has happened, but now we have everything under control, and that between January 1st and June of 2018, there was one incident, because we have all this in control. So one of the questions I would like to know, and council should address to it, it may be outside the record, but it's something that you brought it up. So it's, from my point of view, it's important, is from after April 2018, has there been any incidences reported that we should be aware of?
I'm unaware of any. Mr. Shine certainly can chime in.
I would like you to. That's
Chair,
the whole premise on this thing.
Chair Rosenbaum, members of the commission, there are inherent delays in this entire process. After the charge letter is finalized, we amend it again before the hearing. I mean, the short answer is that, yes, I have heard from inspectors about other events that under normal circumstances would go forward, be investigated, reports written on with this premises, and charges brought or added to the existing charge. But we just don't do that as a practical matter once we've already put forward a long charge, we've had the hearing on it, we're waiting for the ALJ to issue a decision, which was from June until November 1 before or October 31, I think, the proposed order. So during that time, we don't charge new charges. We wait for the ALJ to decide on what we've already charged. And then there's the time period, to get this to before this commission. So during that time, yes, I've heard about things, but we haven't fully investigated them. We haven't brought new charges because we'd kind of be chasing our tail to do that. We've got, other things to do, lots to do.
Sure, Roosevelt.
Yeah.
Two statements. One, when did the Fongs take control of this organization?
13. When did you take control? Trio, 13 or 14? Let me look at the proposed decision. I think it's 2013 or 14. It's 2013.
Yeah. And then the second one is that as a former police officer, we were told at some point, do not buck, all pile on and write more citations or more charges. At some point, it got ridiculous. Is that what you're saying here?
Yes, that's what I'm saying. We have a case. We've made our charges. We presented them. We're going through the process.
Thank you.
And that's right.
Both, thank you.
Go ahead, Council.
Sure, but to address something quickly, as far as the charging document came out in January, Mr. Shine's position that it would take time to add these new instances. The reality is that at the morning of the very first day of hearing, the charging document was amended then to include the April 1st, 2018 incidents. So if there were any others that they thought were worthy to be alleged, they could have done that at the same time too. It was done at the very last minute, on the morning of is when it was amended. So they did have the ability till then. Post then, I'm told there are no fights. I've heard nothing occurring there, but it's that matter. In regard, the police themselves have an obligation to write the reports and report it. So we've heard nothing. But the four incidents I want to address are the ones that were alleged in the charging document, that after evidence was submitted and argument from both Mr. Shine and myself, the ALJ found that they should not count toward a history of serious and persistent problems. The OLCC now is asking that they be included in that. And so I just want to make sure that I make a record on those, because I think the ALJ was correct in not including them in the proposed order and should not be included now. And those instances are one on May 7th, 2016. There was double hearsay statement in one police report where someone told a police officer that, that someone involved in a fight outside the premises was inside Trio. And if you can recall, 10, 15 minutes ago, I talked about this high-tech security system that Trio has, that every person that comes in has a photograph taken of them and their ID is saved, and so it's matched up. What happened after that allegation of the person being inside Trio that started a fight outside is the police worked with security to go through this camera system. No one found a photo. That person wasn't identified, wasn't photographed coming in. If that photograph doesn't appear, then they weren't inside. And so one person's statement that they were inside can't refute the fact that this system was looked at and the photograph wasn't shown of that person being in there. And that's why the ALJ did not count it, is you have a double hearsay statement versus pretty conclusive facts that everyone gets photographed, that photograph wasn't seen. As for the February 19th, 2017 instance, the reasons that the OLCC now wants to include are just wrong on the law. This is an instance where two people were in a car driving, saw a security guard working at Trio, and had a problem with that security guard from another night at another location. And ultimately, that turned into some sort of altercation with them outside the premises. In order to count as an incidence for a history of serious and persistent problems, it has to involve a patron who is either coming to or leaving from Trio in the immediate vicinity if it didn't happen inside. Here, you had no patron because these gentlemen were not trying to come in the club. They were stopped at a red light, and that's how the altercation occurred. Trio, OLCC then tries to argue, well, one of the security guards left Trio and became involved in this altercation. That doesn't make a difference. The statute, ORS 473.315C, is specific that it has to be a patron that is involved in this dispute, not an employee. So the judge got it right in the proposed order, and this shouldn't be counted because ultimately you don't have a patron outside the premises that was involved in this scuffle.
One question, was the security guard involved in that altercation, was that prior to or during the time that they were doing their own security?
It was prior to, so it was an outside third-party
Contractor.
security company. Then addressing the July 16th, 2017 instance, the reason the ALJ did not include this is that there simply is no evidence that the person who wandered off drunk was ever inside Trio or was ever served alcohol inside a Trio. So all there is a CAD report. There was no testimony on this. There was no police report. There's a CAD report. And it just doesn't have any facts in it. It's one person calling, and you have double layers of hearsay, and ultimately no one could show with any evidence that this person had a single sip of alcohol inside Trio, and it doesn't say it. Finally, moving on to August 26, 2017, is a similar issue where there was a gentleman that was outside the location that was detained by security and ultimately pepper sprayed, but there's no evidence in any testimony or any written document that this gentleman was ever trying to get into Trio or was ever leaving Trio, was ever inside a Trio. And the statute requires that it has to be a patron. And if the OLCC wants to include this, then they have to have evidence that that occurred. The ALJ understood that and did not count that instance for that reason. So, but again, these are just for the instances. The main focus of what I wanted to talk to everyone about today was the mitigation and the demonstration that there really is a sea change that occurred here. And for that reason, this licensee should be given the opportunity to continue to operate. Suspension, fine, restrictions, any of those are acceptable, the ones we proposed. But ultimately, I don't think it's fair and I don't think it's right. It doesn't reflect business realities for this licensee to have a cancellation today. Thank you, and I'm happy to answer any questions.
Thank you, Chairman, members of the Commission. I will respond briefly to certain specific points made by Mr. Kroll. First, with the general premise that everything has gotten better with allusions to 2018, I can't stress strongly enough that the evidence before this commission ends April 1, 2018. All parties are simply speculating about what may or may not have happened after that time. It's the obligation of the commission to decide the matter on the evidentiary record, not on what may or may not have happened afterwards, and general statements about everything's gotten better, there haven't been any fights or anything like that, or even general statements I've made that I've heard from inspectors about problems after that time should not be considered by the commission. That's my understanding. When we look at what happened April 1, 2018, the very last chance you have to judge this licensee, it's, as I said, terrible. As the ALJ herself found, he was personally involved in the use of excessive force against an intoxicated patron. He stomped on a patron 2 times with his foot, which is testimony by police officers. That's not how you control suspects or persons involved in disorder. Even testimony that, you know, the licensee himself should leave it to the trained DPSST certified security staff to control disorder. Furthermore, the ALJ was likely well aware, or had to have been aware, that there was an effort to corrupt the process by the licensee late in the game by having one of his security guards provide a statement that came in handwritten that the security guard testified he wrote when he was intoxicated at the premises, copying off of something that the licensee gave him to write, in which he supposedly retracted his statement that he'd previously made to our inspector about the licensee's son spitting.
Excuse me, where does that say that in the information?
In the information before you?
Right.
It's
the
part of the
testimony.
evidentiary record here that this effort.
Were you introducing new information?
No.
I'm just, I want to know.
No, it's part of the evidence before us in terms of why she, you know, made credibility rulings on each party here.
Okay.
The point is that the last thing you have to judge on was April 1, 2018, and this licensee made it very clear, even if it's one incident in that time period, since the last one was the very end of December 2017, and you have 4 more months, you have that one right at the beginning of April, and then we cut off what we did. The law that was applied, I'm going to go back to what Mr. Kroll said. He said that the ALJ applied the wrong standard of law regarding willingness and ability. That's not, in our view, an accurate statement of what the ALJ did. The ALJ cited all the same cases that Mr. Kroll cited, including Girdles and all those other cases, recognized that it's a weighing process, but she had before her the real impact of not only all the cases that happened in 2016, all the cases that happened in 2017, or all the incidents, and this incident of April 1, 2018. So she had to determine whether that one incident that occurred April 1 was of sufficient magnitude that it indicated to her a lack of willingness and ability. And I think that was a major part in her view, that if this is what the licensee is doing on the very last incident, engaging in excessive force against a patron, then this is not a willingness and ability to control disorder at the premises. As for the specifics, Mr. Kroll mentioned that they removed furniture by the bar. there was no evidence no evidence put in that caused problems, that there were any problems with furniture at the bar, that they put in a TSA level metal detector. The TSA level metal detector does not change the problem of intoxicated crowds spilling out into the streets and fighting in front of the premises, which was a significant part of the case. It does deal with weapons inside the premises, but not the gun incidents, the shooting that happened outside the premises. That they increased the cover charge. The record shows that that was done back in 2015. It may have increased again in 2016 and again in 2017, but a gang enforcement team officer testified that in his opinion, criminals and gang members like it when the prices are high because they get to flash their cash around and feel like they're in a special place. And the VIP tables at Trio Club are that kind of place. So that doesn't really have the effect on quelling disorder. The in-house security team, one of the problems with the in-house security team was shown by that incident in April 2018 is that you don't have the independence necessarily of the security team. If you've got a really good licensee, it's great to have an in-house security team because then you're getting good direction from the top. But if you've got a licensee who's not our ideal operator, then he has more control over an in-house security team and can, frankly, corrupt their practices. The permitting disorder argument that was made was that it's not strict liability. Well, please look at the analysis that was done. The judge recognized that knowledge had to be there, and in the first instance, security refused to call police. That is permitting disorder. They're employees of the licensee. That's attributed to the licensee, and that is permitting disorder. In the next, they were well aware of crowds out in the streets fighting, and they weren't acting to quell that disorder. In the third, they were well aware of the fight, that they had taken 3 people and pushed them out into the street, and they continued fighting. The knowledge element was found, and thus the permitting element was found. In the fourth, that involved the licensee personally, the April 1 incident, personally involved in excessive force against a patron, so the knowledge is there. No strict liability was found. That's a red herring. The argument that there is a video, you actually have to produce a video when asked, and we're implying some condition on the we're implying a condition in the enforceable compliance plan isn't correct. The paragraph 10 says licensee will purchase and install a new surveillance video system, and after installation of the system, and the system becomes operational, will ensure staff are trained to produce and supply video surveillance footage to the OLCC upon request. That's a pretty clear statement. They don't just have to know how it works, they have to produce and supply video to OLCC on request. There's nothing to imply there. And they didn't do it after an entire month. And the statement by Mr. Kroll that there's no evidence in the record that the video ever existed is, in fact, not accurate. I went back to the tapes and listened. On June 12, 2018, afternoon tape at 1:48:10 in the afternoon, Inspector Pitton was testifying, and he said, quote, well, over the next less than a month, I had a couple of different conversations at the premises with Susan, and I reminded her about the video. And then on 6/27, I believe it was in an email, that she had responded that she didn't have the video, that she had failed to pull it in time, and that it had been recorded over, period, close quote. So it existed, their lack of training, prevented them from producing it, and they did not produce it. And they violated the ECP requiring them to produce it on request. So that argument is not accurate. With respect to the specific incidents in our staff comments, I'll let the staff comments speak for themselves, and unless there are further questions, I have nothing further.
Questions? I have a couple. I want to get down to the heart of this thing. Counselor, give me the month and year in which your in-house security took place.
It would have been, was it late April 2018, early May? So post the last instance and right before the hearing.
Okay. Give me the month and year in which you put your metal detector in.
Approximately November 2017. We
Give me
have,
the-
I might be able to give you,
No, that's good enough.
okay. We do have a receipt that's in evidence, so it's around.
Give me the month and year in which you have individual photos taken of everybody coming in.
That occurred earlier on,
When?
2015. I'm looking at, I think around spring, summer of 2015 is my best
And
recollection.
that's continued?
That's continuing, they still have it till to
And
this day.
would you explain to me what you do? You take photos of everybody who comes into the,
Yeah, so what happens is when people come into the premises, they will give the identification. That gets put into a machine, which then scans and retains the identification. At the same time, a photograph is taken of that person, and the ID in the photo are then saved in the system for that night. So every single person that comes in has to go through this process. And so therefore, every single person in Trio on a Friday, Saturday, or Sunday night from 9 p.m. till close has not only their photograph taken of how they appeared when they came in, but the photo and the information on their identification. And it was the police that had suggested this would be a good idea, because if there were instances or incidents, then you could really pinpoint who these people are. And throughout the evidence that was submitted, there was one or two instances where it actually did assist the police. I don't remember the specifics now because it wasn't a major issue.
give me the month, year, and the amount on the latest cover charge.
I'm looking at Suzanne, who's probably the best person to.
25 for guys and 20 for ladies.
And when did you institute that?
About a year ago?
That was yeah. So $25 for men, $20 for women. And I remember it being, and it's consistent with what she said, about a year ago, so December 18, January, December 17, January 18.
And, Mr. Chairman, page 40 of the proposed order, the ALJ has stated the dates of many of these changes. And in an effort, it says there, in an effort to improve the caliber of its clientele, licensee has raised Trio Club's cover charges and drink prices, and in approximately 2015 or 2016 stopped offering a happy hour and drink specials.
No,
The-
I know that, I just wanted to know the latest one and how much it was.
Thank you, Chairman. It is a constant upcrease. The latest one, the one that's currently being used now, is 25 for men, 20 for women, and that was instituted December 17, January 18.
December 17, January 18.
Yeah.
Okay.
Yes. And it's remained the same since then.
Okay. Any other questions?
Sure.
One question.
Go ahead.
You guys are operating till 2:30, 7 days a week, just weekends?
I think we're allowed to practically, I wouldn't mind, Suzanne, would you mind just coming up here? Certainly on Friday, Saturday, and Sunday, it's still 2:30. What's the reality Monday to Thursday? They close at 2 on Monday through Thursday.
Go ahead. Sure. Counsel, you indicated that the Fongs owned another restaurant, Ambassador,
Correct.
and there was some cleanup that was involved with that.
Yeah, early on,
So the question is,
okay.
how many years did it take you to clean it up?
Well, anytime anything happened,
You need to identify yourself, please. Please identify
Sorry,
yourself.
this is
for the
Suzanne,
record.
Suzanne Fung, who is the general manager.
Okay.
I'm gonna look at the record. My recollection was it took about a year or two to hash things out at the ambassador.
A year to clean that one up and 3 years to clean this one up.
Pardon me?
A year to clean that one up and 3 years to clean this one up.
Each location has different problems.
The answer is yes. Is the answer yes?
Yes, more or less. I mean, like I said, the ambassador might have been a year or two. I don't want to say exactly a year, but
So they bought in 2013, 14, and then it's 2018. That's why I asked the original question. When did you take control?
I understand.
So the answer is yes.
Like I said, my hearing's not great as I have a cold. The answer to, I think, your question is.
Thank you, Counselor.
Thank you.
Commissioner Melendez, did you have a question?
Well, no, it sort of relates back. The ambassador, is that, I always pass it. Is it more of a restaurant or is it more of a lounge? Like, I'm familiar with Trio, but is the ambassador, is there dancing inside of it or is it,
Yes, there's dancing inside of it.
just trying to compare the two.
One final question. You've asked this commission to basically think outside the box and help you stay open by doing whatever we can to continue in the interest of the public of protection. So you've got an in-house security staff, you have metal detectors, you have individual photos of everybody who's coming in, you have a large cover fee, either from you or Mr. Fung. Think outside the box and tell us what else we could do to keep this place open without having the horrendous amount of violations that we've seen over the last 3 years.
Well, what we had submitted into evidence, and I have copies of, is the restrictions that we had suggested that if cancellation was going to be the decision, that we would propose these restrictions in lieu. I do have 5 copies of them for the commission if it.
I understand. I want to hear from you in your own words. What do you think we should do?
In lieu of cancellation, I think the appropriate thing, if that's the route the commission is going to take, is to stop the sale and service of alcohol at 1 a.m. As I noted, all but a handful of the instances happened after 1 a.m. The restrictions talk about, having no possession of alcohol at 1:45, and then there's some issue about the close at 2 a.m. And the reality is having a hard close actually sometimes causes more problems. But I think the issue really would be to have the cessation of alcohol sales at 1, and you have 45 minutes for people to finish that last drink and allow them to casually leave the premises. I think the licensee has done a good job of changing culture. I think that restriction, more than any of the others, will set a more definitive tone as to what the culture is at Trio. I have everything else that, and we had some back and forth with the OLCC staff before we went to hearing and issues, and I get the sense from them, and it's the alcohol hour, and I think that's the main one. The other restrictions I think are helpful. A lot of them they're actually already doing, but if you're asking me my honest opinion, I mean that's the restriction. I think that could, if I was the commission, I think we'd rather see that than cancellation. And I think from the commission's view, I could understand why that'd be imposed.
Chair Rosenbaum, if I could speak to that.
Sure.
Having spent many hours talking to Inspector Pitton, who has this premises, 20-year veteran of Portland Police Bureau, he feels that the culture at Trio Club is directly, and he testified to this, directly the effect of the person in charge. And with this person in charge, it's not going to change.
The commissioners will now go into chambers for deliberations on contested cases pursuant to ORS 192.690 sub 1. Once the contested case deliberations are complete, we will then return to open session to make a decision on the contested cases.
Do we wait for Steve? Close the door.
We are now back on record. Commissioner Revelle?
No, Matt. Matt.
Right, Commissioner Molatus first.
I just wanted to state on the record, on January 4th, I did receive an email regarding Trio Club. It was not part of the record. I did not show it to any of the fellow commissioners, and it was not part of our deliberations.
Are we gonna do that second part?
No,
Oh,
there's
as
nothing more
far
we
as-
need to do.
Is that it?
That's it,
Okay. Chair Rosenbaum.
Commissioner.
In the matter of full on-premise sales license held by Trio Club, Inc., doing business as Trio Club, I move to amend the proposed order consistent with the comments submitted by staff and to issue a final order canceling the license.
Any further discussion? Take the roll.
Commissioner Curran,
Yes.
Commissioner Harper,
Yes.
Commissioner Molinas,
Yes.
Commissioner Revelle,
Yes.
Chairman Rosenbaum.
Yes.
Thank you.
Thank you.
Okay. Give me 1 second and. Okay. Alcohol stipulated settlement agreements.
Good morning,
Good
Chair
morning.
Rosenbaum, Commissioners. I'm Nicole Mitchell from AP&P, here to present the stipulated settlement agreements for ratification. There are 6 liquor cases and 5 marijuana cases. I'm happy to answer any questions.
Commissioners, anybody have anything? I do, but
We're discussing both.
No,
Just
just one.
alcohol?
Just
Okay.
alcohol.
Then I will save my comments till
Thank you.
later.
you gotta give me a second to get to it. I hate this thing. No, I got it, but, no, which is the one that, is there a one was a cancellation of the license?
The
Oh,
horseshoe saloon,
Yeah, which one is that?
Saloon.
I'm having trouble with my,
Chairman, that is numbers 5 and 6.
okay. Just give me a second. So you got 2 of them here. The question that I have on both of them is, we're canceling this license. Is there something in the statute that prevents us from issuing a penalty or a fine as well as cancellation of the license?
Well, in this case, Chairman, there is a letter of reprimand that will be issued that will go on the licensee's record.
Right, but
But
I'm
there
not
is-
interested in that.
Once the license is canceled, we lack the authority to issue any civil penalties.
So do we need a change in statute in order to do so? Because the same thing happens with the marijuana license. We can't issue a fine if we just cancel the license, right? It's not if just, but.
That's correct, Chair Rosenbaum. For the record, this is Kelly Rapp, Director of Administrative Policy and Process. So cancellation is the highest penalty. If we don't cancel, then we issue penalties less than that. So we would, because we are canceling the license, we wouldn't also issue any sort of monetary penalties or suspensions because we are taking away their license, which is the most serious penalty that we could impose upon them.
So let me ask you a hypothetical question. 5 years from today, this person wants to apply for a license again. If we had a penalty on it, they would have to pay the penalty before they could apply for a license again, right?
No, that's not correct, Chair Rosenbaum. We would, when we cancel a license, or if they've already surrendered it and we impose a letter of reprimand, the violation goes on their record, which is what we would evaluate in determining whether they would be eligible for a future license. But we wouldn't then collect any penalties from them because the license was already taken
Oh,
away.
you can't now, but if you
Right.
change the statute, you could.
I suppose when you change statutes, you can do whatever you want. Yes.
So there's nothing, there's a statutory prohibition against us canceling a license and issuing a fine at the same time.
I'm not aware of any authority that would allow us to do that, because cancellation is the most serious penalty, so we wouldn't also issue lesser penalties for that.
We have to do this in open record. Is there any sentiment on the commission to not only cancel a license, but increase a fine? Or create a fine as well as the cancellation of the license?
The intent of that would be to later down the road, make sure that, I think that, we want good actors and having something like that, follow them to where, because I think if the intent is to make sure that, if somebody's gonna come back and reapply to their, that's probably a compelling way to go about it. I'd be for that.
Although, to clarify, if we were to assess any penalty against a licensee, when we evaluate for future licensure, we don't necessarily consider what the penalty was, if it was a civil penalty or cancellation or a letter of reprimand. What we're looking at is the actual conduct that occurred. So if it was a Category 1 violation, we would look at whether that made them eligible for future license. So it isn't necessarily that they paid $10,000 and was canceled. It was that they have a Category 1 violation on their record. Once we cancel a license, we no longer have any jurisdiction to issue any sort of penalties on them after that, aside from a letter of reprimand, and that is a statutory limitation.
But if there was a serious violation and we canceled their license, why couldn't we give a penalty as well?
I suppose that's something we would have to look into. So it sounds like you have an interest in not only canceling a license, but also accepting, collecting fees, or I don't know the purpose of serving a suspension when you are canceled, you no longer get to operate.
I think this is worth a 5-minute discussion,
Okay.
okay? I'm reading this, and, there's some serious violations here, and it warranted a cancellation. And I said to myself, where's the fine? Because I know there's a cancellation, but the factual situation is such that, to me, I think a fine should be on top of the cancellation. And Steve, you got any comments on this?
Well, Mr. Chairman, when I was new to the commission, I had the same reaction, and kind of the realization of how statute works here. But, and we use, the letter of reprimand. They don't have a fine. It does get bad actors out. It gets them out expeditiously. It helps us settle cases because, and maybe in part because that's not there. On the other hand, they have had contact that would have been a fine otherwise under our system. And it does seem like, to me, it did seem like that was a question. I haven't raised it in a while, but it's an issue that, just that catches you a bit wrong, right? And it did me when I was initially here. I understand why our system works like it has worked and does work now. So it is something that we could look at, whether we could use a device like that as a tool to provide the right kinds of incentives in the system to think through how you would evaluate that in a potential relicensure. That whole process is really based on an evaluation of their past their past history. Whether we bring that into play at that point would be a question that's a process that, how long you wait out, how many years you have to sit out is an evaluative process. process is not set up in a standard of time, which I've had to explain to many legislators as they were looking at our system.
Chairman, I don't think there's a need for an additional penalty. We've taken their license and they're not working. And here in Oregon, if you don't work, you don't have any money. If you don't have money, that's an additional burden on this prior business. So the reason why we don't have a cancellation and a fine pretty much is because we give an option on all these cases to pay a civil penalty to stay in business. So if we start canceling and then having them pay a fine, are we saying that they're gonna go back into business? So to make it really cut and simple, cancellation means cancellation. Thank you very much. A penalty, if they choose to accept, they have two options. They can pay the fine or a civil penalty, or they can just close their business for the number of days, and they have an option to come back to work. I do understand that people want more, but what else more do you want? They've done something maybe out of their control as a business owner, and we decided over a course of time to cancel. And I mean, we just had a big case earlier about the same thing. This guy's huge investment back in his business, and we canceled him, and we don't even need money from him. So that's my position, but I do understand that there's a perception that we could get, people do wrong. But we have another case here, people running around with box cutters trying to kill a person. Well, what kind of fine am I gonna give him? The number of steps?
A big one.
Yeah. Well,
But he missed. He didn't hit it, So I think if you want to table it, I think it's great, but I know citizens of Oregon, they say, go, peace out. But it's...
Well, we have a mix of good new commissioners and experienced commissioners, and to bring these things up, I think it's important to just think in different terms. I just want to get a feel for the commission on how they felt on it.
the thought I have is that the licensees, anybody that's in the system is our partner. And there's to me, I draw a distinct line between good actors, bad actors, and that's kind of it. And there's gray areas, and we've got to consider it, but people that are earnestly trying to deal with issues, making the job on the inspectors easier, on the agency easier, working with us in tandem, that's, we don't want to find them if there's a thing, but people that are persistent problems that cost time, energy, and money of the agency, when they're on their way out, I don't know that I think it's a bad idea to at least have the ability to ding them while they're on their way out, because, and I think that isn't speaking for the bulk of the licensees in the because most of them, 99% of them are great. It's the 1% that are a challenge, and I think that having that extra tool in our arsenal is not a bad thing.
I think 100% of our businesses are good because they win in the business. There's some places that need to be for bad people. Okay?
Why are you looking at me?
I'm just looking at the police officer. It's a plethora of individuals in this state, and we can't have all goody bars. Okay? It's got to be some tough ones out there, and the tough ones have tough owners. And so, maybe, I see the good bars having the problems. The tough bars, they good to go. So it's 100% of everybody that we allow have a license, and we do the vetting. So we just can't turn around and say there's 1% that does wrong.
Okay.
Because we select 100% of them.
All right. I think that I think you disagree if you walk into some. I mean, I don't know.
Some bars they know I don't go.
Yeah.
Do you want me to get out of the way?
They got some bars that's for little people. Some people for big people.
There you go.
All right.
Okay. Don't go to the little people bar.
If I may add to this as well, I agree with you as far as wanting to make sure that we have the appropriate amount of penalties for someone who is a really bad actor. And we see those cases. But I would say a penalty upon cancellation, one, the cancellation acts as a fine in the sense that it's taking money away in a different way. It's not coming to the agency, but it is taking money away from them. And second, practically speaking, it is going to be impossible, well, not impossible, but it'll be very difficult to enforce and collect a policy like that, because once those people are gone, then it's going to be our job to track these people down and try to get collection of that. They're not going to have an incentive to pay the agency because they're not going to be trying to brown nose us or be nice to us anymore. They won't have any incentive. They'll have moved on. They're going to be doing something else. And so it's going to be, something like paying your attorney. I'm not going to do it. I'm just going to throw it in the garbage and nothing's going to happen to me. So I would be worried, practically speaking, that it would cause more time, cost for the agency without it having necessarily an incentive that somebody would be saying, I might get cancellation and a fine. So, but I think it's a good point that we want to make sure our penalties are addressing those bad actors.
This discussion is well worthwhile. In all candidness, the reason I brought this up was I wasn't so much concerned about the alcohol aspect of it. I was much more concerned about the marijuana aspect of it. And when you take a look at, this Evo Labs that we have coming up, that's pretty outrageous in some ways, to me.
Mm-hmm.
So this is a new field. We're responsible in public policy to do all we can. And to me, to bring this up now and for us to consider in the marijuana aspect of it, a fine as well as cancellation, I think is a lot more important than the alcohol end of it now, maybe not later. Maybe if it's in our toolbox, it's worthwhile. Just to have it in our toolbox. We don't have to use it, and I don't think anybody in this commission wants to punish anybody. That's not the issue. But there's going to be situations where it may be available to us, and it may be very beneficial from a public policy point of view.
Sure.
So that's the reason I brought it up.
Being that, did you say experienced or senior or old?
I said experience.
Experienced.
I didn't say, I'm not that stupid.
Being one of the experienced commissioners, early on, we had working lunches with staff to take a look at the level of penalties and how they fit. Perhaps it would be a good idea to have something like that again, where we could have an open discussion, because we depend on staff to come up with recommendations as to how we deal with violations across the board. So perhaps we could have a working lunch and have everything on the table and look at what the options are. And that would help us move forward in the future.
That would be helpful.
I hate being reasonable. So if we could do that, Steve.
Yeah.
Thanks.
Commissioner Reval, that'd be entirely appropriate, and I think, and possible, and something we should talk about laying out in our lunch work session today about when we could get to that. And I'd just add to Commissioner Kern's comments, I do think collection and going out the door would be a problem, but what ends up happening is some of these folks eventually come back, and we reevaluate them. So you would be able to collect at the time they were coming back into the system, and maybe that's not quite the right way to look at it. Maybe we just want a fee on that evaluation we have to do when they come back into the system, because they've caused us
Right.
the time and energy to have to do that evaluation.
That would be appropriate.
So there's other ways to look at
Sure.
obtaining some of the same in some incentives, not quite the right
And
word
it's
that
that- but
captures the whole
It
thing.
would be somewhat like a tax.
Yeah.
You're a person that's cost us a lot of money, and we anticipate that we're going to have to monitor you. So,
Yeah, Commissioner Robel's comment, I think it would be very beneficial if we could have that type of open discussion on it. That's all I'm really asking for.
Chair, and no tax.
No
Commissioner
tax.
Harper is against that, so.
yes.
I have a-
Okay.
Chair, I have a question. In regards to case number 5 at Hort, the one involving not that one, but the case involving number 3, DVS and DV8 and over-service, and then the cook came out and was chasing the patron down with a knife. Can you sort of explain to us how in the future we will be, if this occurs again, how many times it will take if this bar did this again? How long would it be before the opportunity for us to cancel this business come in front of us?
Thank you, Commissioner Harper. The charge in this case is a Category 2, which is the second serious category. Typically, permitting disorder is a Category 3, but because this involved a dangerous weapon and caused serious injury to an individual, it was charged at the higher level. The second Category 2 violation within a period of 2 years, would that be?
Would be proposed cancellation.
Would be a proposed cancellation, so
All right,
this
thank you.
would,
Next time,
yeah.
it happens, in 2 years.
All right, thank you. And that's anybody that works at that business?
Correct.
Thank you.
Any further discussion? I need a motion, please.
Chair?
Commissioner Harper?
I move to ratify the 6 stipulated settlement agreements as proposed by staff.
Commissioner Curran?
Yes.
Commissioner Harper?
Yes.
Commissioner Melinas?
Yes.
Commissioner Eval?
Yes.
Chair Rosenbaum?
Yes. Marijuana?
Yes, there are.
Any questions?
Chair?
Commissioner Harper?
As each month comes and goes, I always am interested in cameras. So I'm looking forward to our discussion in regard to collection of information and the usage and placement and number and off-site, on-site cameras. So I appreciate the cases. And I just want to make reference to case number 5. We talked about the lab that held that retained the additional candidates for testing. And so in regards to that retention, can you sort of explain to us what is the current policy when they do receive 2 halves, when they do the test, and the other half, how do they dispose of it?
Commissioner Harper, there is rules on how to properly dispose of waste. Some of that I would think would be internally, it would depend on the policy of the lab, whether that be just incinerated or if they take it to a separate place for proper destruction.
Because I'm sure that the producers that own this product, do they have an option to get it back? Or is it something where, they provide it for the test and they take half for the testing, and if they don't need a retest, which from my understanding in the reading, it could be up to 3 weeks to a month that these labs retain this product?
Commissioner Harper, there is a waiting period for the samples
To come back.
to be retained before they can dispose of it. I'm not sure if that's a 2-week period or a 3-week period.
And so our issue here is just they gave it to their workers.
Yeah, they had a policy that allowed them to give the
Excess
retention
product.
samples to employees.
Thank you.
This is maybe more of a discussion piece, but a lot of these that I'm seeing lately, we required all of the owners, all of the investors to be on the license. It's tricky because when you see these violations, maybe somebody that was a passive investor is now being dinged for a violation, and a lot of these were shotgun marriages, people that got in, or they were just trying to put capital into the industry. I guess what my question or my thought is going forward, how are we, one, notifying somebody that may just have a passive interest, and what ability are we giving them to sort of respond? And then 2, it's a challenge, and I want to frame this the right way. it's a challenge when this industry is so capital starved, and I think the way forward ends up attracting more capital to the industry. I hate to ding people that are willing to invest. I just think it's a thought of we may be able to look at how we can be more surgical in terms of reprimanding the violators versus the investors as well as the violators. And I don't even know how that could be accomplished. It's just something that has been brought up several times, and I think it's a unique situation that we're dealing with, especially in marijuana, where there was so many people coming into the industry that may not have, we don't necessarily want to penalize them, but we certainly want to penalize the bad actors.
Commissioner Melides, thank you for your comment. Do you have any?
Yes, I mean, I think that's a good topic for discussion, Commissioner Melides. I will say that, you know, our regulations are structured in a way that we require collecting information from certain parties who have a certain threshold of interest, and they do assume the risk going into this, that if they're, you know, providing a certain amount that would create an ownership interest that would require them to be on the license, that should anything happen, that they are responsible as being part of an entity or on their own. So they are somewhat assuming the risk of any conduct that occurs, and we do hold everyone that's on the license jointly and severally liable for that conduct. So, but we're happy to discuss those sort of issues in the
And I
future.
guess a thought is how, then it's really important how we're notifying some of those passive investors, especially if, let's say, they invested into a business, they may not be there on a day-to-day basis. Maybe we give the person responsible for the violation, but it may not trickle back to some of those investors. I'm not 100% familiar with our process in getting stuff to them, so I think for that discussion it'd be helpful to have some of that information.
That's a great comment, Commissioner Melides, and we could certainly talk with licensing staff about their current processes and if there's anything that we would like to pass on to, you know, the various nested individuals.
That'd be great, thank you.
Chair Rosenbaum.
Commissioner?
I move to ratify the 5 stipulated settlement agreements as proposed by staff.
Commissioner Curran,
Yes.
Commissioner Harper,
Yes.
Commissioner Melides,
Yes.
Commissioner Reval,
Yes.
Chair Rosenbaum.
Yes. Just as a matter of information, for those of you who are interested, especially in the alcohol field, the United States Supreme Court heard a case yesterday involving the state of Tennessee, in which, if they look at that from the strict residency requirement opportunity, it'll be quite limited. If they look at it any further in terms of interstate commerce and the 21st Amendment, it's going to have profound effects on the liquor industry, profound effects on it. What they are, who knows, but especially if any of the commissioners want to take a look at that, you should. We're ready.
Morning, Chair Rosenbaum, fellow commissioners. For the record, my name is Bryant Haley, Compliance Specialist for the Oregon Liquor Control Commission. This morning, I'd like to introduce the new Rules Coordinator, Emily Feblis. Emily comes to us from North Carolina, and Washington State before that is working on industrial hemp rules. So with the passing of that next month, or coming before you next month, it's opportune. So.
Thank you. I'm very happy to be here.
With that said, I'm going to jump right into the two packages we have today. First off, we have the alcohol rules license rules package. The proposed rule amendments address 2 issues in regards to alcohol licensing. The first the first amendments to 845-005-0311 clarify ownership interests in a licensed business and add examples of when the commission may waive an applicant's ownership interest. Next in the package is 845-005-0325, which clarifies how the commission considers factors that either support or overcome a license refusal basis. Further, the amendments identify specific factors the commission will consider when refusal basis has been found for an applicant due to the applicant's record of relevant convictions. With that said, I'd be happy to answer any questions.
I think we've talked about some of these issues a lot, and I appreciate everybody's time and attention to this, and I think everybody's ready to move on. on and figure out what the next step is on it, so I have no more comments at this point.
Chair.
Yeah.
I move to initiate rulemaking to amend OAR 845-005-0311 and 845-005-0325.
Commissioner Curran,
Yes.
Commissioner Melinas,
I'm sorry, this is just on the move to rulemaking?
Yes.
Oh, yeah, first
This is
Initial
initiated,
action.
yeah, agents
Yeah,
next.
it's-
Yes.
Commissioner Harper,
yes.
Commissioner Reval,
Yes?
Chair Rosenbaum.
Yes.
Thank you. Next up, we have the agent limited license package. The commission this past spring received a petition which requested the removal of the prohibition on retail sales agents' ability to obtain a liquor license for a limited liquor license for a separate location. ORS 471710 explicitly prevents a retail sales agent from obtaining or being associated with either a full on-premise license or a distillery license. The statute is silent upon whether a retail sales agent may obtain other liquor license types. The amendments would enable a retail sales agent to obtain a limited on-premise sales license, allowing them to serve malt beverages, wine, and cider for on-premises consumption at a location separate from the liquor store. That said, I'd be happy to answer any questions.
Chair Rosenbaum.
Commissioner Revelle.
I'd like to take this opportunity to thank staff for the many, many hours that you put forward to help us understand what the impact of this rule change could possibly be. At first glance, it was somewhat confusing for me, but after spending time with the team, it's been very clear as to what it will and won't do, and I do appreciate your efforts.
Thank you.
I agree with that.
Thank you.
Thank you.
I absolutely agree, and I second that it was a great effort, because I know this is a very confusing and complex issue where we're blending privileges to a certain extent. I think we've had some good discussions on it. I think it's allowed me to understand how to work with staff, because we've been dealing with it for quite a while. So
Almost a year.
again, really appreciate it. I really appreciate all the members of the industry that reached out. I think regardless of where the decision is, I think we've got some ways to address both the concerns and the non-concerns, regardless of what the commission decides. So thank you all for educating us on that.
Thank you, Commissioners, Chair Rosenbaum, Commissioner Melias, and the rest of the commissioners. That's why I said throughout rulemaking that we were going to do thoughtful rulemaking on this. I think we really did think through. We worked with our partners and the different sides of the industry that had differing thoughts on these issues. But I think all the cards are on the table now before you. So if you have any further questions, happy to answer them now.
Let's take the roll.
Well, I would say my understanding is that there isn't any concerns from the commission about vertical integration or competition on this.
Yeah, Chair?
Yeah.
I have a concern, and I'll tell you up front, I'm gonna vote no. And the reason why is there is no guarantee or no application that can determine if a retail sales agent can perform the duties of owning an off-location separate site to do what we're asking. And I just feel that I do not want to be in a position to set someone up for failure. For the last 7 years, I've been here approving these new agents in regards to what they do, and from providing an exclusive and non-exclusive license. But it's difficult to license something in somewhere where everybody knows your name, and there's no guarantee of success. But it's true, the state doesn't get any income out of this. I mean, we're just doing this as a service. I understand it's a privilege. But I just feel at this point that personally for me, there's no other need for a conversation in regards to allowing this privilege. And I do know that there's one agent that would like to take this on. But I don't, in licensing this, the paperwork says for the distribution of what we provide as agents. And I've heard case after case of companies and businesses that just could not control the consumption of alcohol on the site, and now I'm asking my agents to do it, take time away from their stores to provide this service. And I understand and can provide some income for a lot of people, but again, it's additional businesses in our state that may cause harm, or may provide somebody with more income, or I've heard earlier, provides people with jobs. I understand that. But I just wanted to make sure, Chair, that I was open about this and not hiding behind a a vote of no. So I appreciate the commission allowing me to have my feelings. I know everybody here has a different position, and thank you, Chair. I really appreciate this.
Sure, I'd say something too. And I'm in agreement with Michael. I also have concerns on it. I'm still a no vote. The fact is, though, I think that it was great what the staff was able to do in really educating us. And so I think our fellow commissioners have all the information. That's what I really wanted to get at, is because Commissioner Harper's sentiments are accurate. There is that concern. I also think there's a significant concern on competition, getting into the line of business. I think there's a lot of things that could come with this. Whatever happens, I think we have to really look carefully at it. But I feel very comfortable, at least in my role, that I've tried to make sure that we keep the conversation going and everybody's as educated, and staff has done a fantastic job at doing that. And so I feel comfortable, whatever the decision is and whatever comes out of it, that we can address those issues. But I am still a no vote, and I'm as along with Commissioner Harper. But that being said, I think we're prepared to.
Now we're getting into it. I like this. Go ahead.
Well, Chair, I am a yes vote, and I do think it's important, and I know that where you are, but if there's anyone else on the fence, I would say that in looking at this issue, we have to first start, I think, with why we have the rule as it is, and why is it there, and so that we can first understand if there's any reasons for it being there, and what those objections are to changing the rule. Right now it's a restriction to our liquor agents to enter into a business that does not have to do with liquor. And so I look at this restriction, and if we are going to continue a restriction on our liquor agents, we better be doing it with a good justification. And so that's what I'm looking at, is it is not our job to be telling these liquor agents, I don't want you to be spending more time or taking more time around your business, or we might be setting you up for failure. That's not our job. Our job is to help our liquor agents and to give them as much success as they can, and see what they can do. And especially these people who are operating and doing good business in the state of Oregon, we want them to continue to do good business. And I'll say, in my opinion, I've heard two objections to this. One is vertical integration. And again, this is where the education of the staff was helpful in showing that this has no, in my opinion, if I'm correct, this has no bearing, or it doesn't change the distribution or sale of liquor. This is beer and wine, the rule changed. So vertical integration is not a reason to object to this. The second objection that I've heard, particularly from Orla and others, is competition. And I make a distinction between healthy competition and unhealthy competition. And our job isn't up here to be limiting people into an industry because the people in the industry don't want more people able to come onto their turf. I see this as healthy competition. It is a small group of people, for one, and they are people who have knowledge about the beverage industry. They're people who have probably done things safely and are doing things within our constraints of public safety, if they're moving forward in with these constraints. And so I would want to encourage them to do that. So I don't see the competition objection, which has really been what the correspondence that I've received, that it would be unhealthy competition in any way. It is more people, and again, it's just our liquor agents, so it's going to be a very select few of people that would be able to get into this, and they're going to be competing for space and for patrons as if everybody else is. And so I think that it's not our job to keep them away from that in this situation. you know, I've looked at a few things. The Orla letter, and I appreciate, but there are members that were in support of it, and there was some that needed more information, and I think that it wasn't an overwhelming number of members that responded that were in objection to it. So I think that that is important. And I'm concerned about when this rule went out, people do need education to kind of go through the details of these rules. So I'm not sure that they may have just been objecting because it seemed like more competition. But I would say that when we limit and restrict businesses, such as preventing a group of people from engaging in a business in the state of Oregon, which I think Commissioner Harper is usually against, limiting people from entering businesses. Right, Commissioner Harper? You want more business.
See the advantage of being a good attorney?
I haven't spoken yet.
We should do it with a significant justification. And just because we've done things one way doesn't mean that it should be done the way, it should be continued that way. And so I don't see at this time a significant justification to give that privilege to our liquor agents, particularly the ones that have been doing very well for our state. And I would support our liquor agents having the right to get into this business. So I would support it, and I would encourage everybody to look at it with the education of the staff. Anyway, that would be what I would say. Sure. It wasn't a closing statement.
He had a turn.
Well, he can have another one. We don't.
Well, I can't ever imagine Commissioner Harper being able to hide behind anything. Or no vote. When this issue first came up, it was quite confusing to me because I didn't know where it was coming from or why it was coming. It was due to the staff's work to let me know what was at stake. I don't see this as a way that will threaten our spirit sales. It is no secret that I enjoy all the areas that we are involved in, from the bottle bill to the cannabis industry to whatever we do with hemp to, you know, the spirit industry as a whole. I can't say that it's my role to tell another business person what kind of business to be in. Each of us takes risks. When you stop that 9-to-5 job for someone else and you decide you're going to be in business for yourself, you take on that risk. You take on that responsibility, and hopefully you have great success at whatever you do. So I think it's important for us to allow the men and women who want to enter this, who we already have strong relationships with, to take it upon themselves to decide whether or not this is a path that they want to be involved with. It will not hurt our organization. It will not hurt the state. I think it's important that we're able to allow this movement forward. It is healthy, and I believe it is right. I will probably vote yes.
Commissioner, I'm just overwhelmed with pride that you feel that the ability to retain the current business and add another one would be a benefit to the state. But my concern is the health of the state in regards to additional locations and places to provide beer, wine, or growlers. So I guess I'm on the side of the health industry. We're a pretty healthy state right now in regards to where we are, but in regards to reviewing this, I didn't hear from organizations that talked about, you know, alcohol consumption. I didn't hear about and having companies step up and talk about where we are in regards to having more and more people going to a different establishment, and that where we provide, you know, beer. I just call it alcohol, call it what it is. So I do understand it's only certain locales that people would like to do this. And by the way, it's only certain people that have the income to start it, or actually the knowledge. So my hat's off to the couple agents that want to do this. but I represent Congressional District Number 5. And Salem, Lake Oswego, we're controlling. We want to control these things. But at the end of the day, it is still taking people away from a business that we sat here and watched them give their proposals in the past and tell us how they're going to run this business. That created that security plan that I saw and I voted upon. And now I'm giving the potential for the same businesses to provide and have another business. And I do understand that it could be good for them, but today is not good for me. And so I just, if we can keep this straight in regards to health, in regards to where we are as a state, in regards to looking at this again in a way that keeps us here on the commission, you know, excited about where we are in this incredible field of alcohol, I think that's going to be okay, along with cannabis. But I do understand that, and I'm outvoted anyway. So, but I just wanted to share with people that it's still an opportunity for us to discuss the health of where we are. So,
I have one final thought.
yeah, thank you.
The discussion on vertical integration, I think I just wanted to touch on one thing. The one part of this where the agents are given a privilege that other licensees aren't. So it's, if vertical integration isn't the proper term, but it's maybe more blending of licensee and agent. I think that's an apt concern, and digging into this, I've realized that there are ways to address that either way. So, I mean, I'm again, still a no vote, but I do think that some of the concerns are not vertical integration or blending the privilege of licensees. We can still address that regardless of where this goes. But again, I concur with what Commissioner Harper said and a no vote.
Well,
Go ahead.
I'm kind of smiling because I'm the swing vote on this. And this audience has to understand, by statute, we do not talk to each other on how we're going to vote. I'll probably say it another 15 times over the years. We can't talk to each other, but we do our homework. And I'm very proud of all of the discussion around here. It makes a hell of a lot of sense. The competition issue was very articulately described on both sides of it. Commissioner Harper doesn't know how this is going to end up because we don't discuss it with each other. So here's my feeling on it. I've been taught my whole entire life that if you're going to negotiate, you better start off with a high number because you can always go lower, but you can't go higher no matter what it is. This issue to me is limited in scope. If we make a mistake, we can change it. But if we don't try it, we're never going to get there. So, I mean, from both sides, I think it's very, very articulate, the issues. Let's take the roll call.
Chair Rosenbaum.
Commissioner Robel.
I move to amend 845-015-0115, effective February 1, 2019.
Commissioner Kern,
Yes.
Commissioner Harper,
No.
Commissioner Molinas,
No.
Commissioner Reval,
Yes.
Chair Rosenbaum.
Yes.
Fair. And we've spoken about this before. This was not knowing where this was going to go. I do think both in our the rules advisory that we were considering, as well as if we could look at this again, just to make sure we're really being cognizant of the impact of the industry if this thing gets out of control. I personally want to be as involved in any of these when these issues come up, and maybe look at this down the road in a year, because I know there was some pretty significant concerns. So I just want to make sure I'm doing all I can to be mindful of the individuals that raised those concerns. Will we be able to look at this periodically again if it is causing concern?
Commissioner Melitas, yeah, I think we could schedule a year out. That sounds like a good idea to see where this goes. We could have retail sales and our licensing department look at the numbers and see how many people have applied, take a look at any infractions or anything like that that's come before us as a commission. That may be a good scope to just see where this has gone in a year and who's taken advantage of this and what the concerns are at that point.
That makes me feel a lot more comfortable, and I
Thank you.
appreciate that. Thank you.
Thank you.
It's going to be once a year at most that we have a vote like this. It just doesn't happen. Steve?
Mr. Chairman, recognizing the issues here and the education we did, part of the constituencies out there that pay attention to us didn't fully have the benefit of seeing that. We're going to make sure that that information you received as part of the record is posted online so people can understand at least the context in which the commission considered those issues. And to Matt's point there, we will watch this, see it, and certainly those industries always have the right to petition us for changes if they see unfair competition somehow developing out of this action you've taken.
Thank you.
Thank you.
Before we go on to the next issue, we're going to take a 5-minute break.
Thank you.
Curran? Well, she'll get here when she gets here.
She's here.
I know. Brian,
Morning,
you're on.
Chair Rosenbaum, Commissioners. For the record, Brian Fleming, Director of Retail. I'd be remiss after the long dialogue to not report out about successful businesses, one being liquor agents. December exceeded sales a record $74.1 million, first time ever over 70 million, and about a 6.4% increase in a big month like December, so a big increment to the forecast. Thank you. Now we'll move on.
No, thank you.
Today we are here for appointment for the Woodstock location. This comes as a result of retirement resignation from Robert Bob Huey. Bob is here today somewhere in the back, 32 years of service, and said it's time to hang it up. What I have before you is 5 applicants that'll present their business plan for the Woodstock area. And with that, this is about approximately $3.2 million store annually, and I'll just start bringing them up.
Chair? I'd like to give Bob a big round of applause for taking care of Commissioner Harper.
Stand up.
Always being nice. Big man store.
I'm glad you said that.
You're always nice to me. I did a drive-by a couple times.
Okay, here we go. With that, we'll bring up our first applicant, Troy Dean. These will be all hard copy presentations today.
Good morning.
Thank you.
Thank you.
So much.
Leave one right there with Steve.
Are we going to give them 5 minutes?
How much time do you got? I got a clock.
I
Okay,
don't
with
know
that,
how
go
much
ahead
time
and
do we
state
get?
your name for the record.
Hello, my name is Troy
How much time do
Dean.
you want? How much time do you want each one to have? How much time?
Normal,
Which is what?
5 to 7 tops.
7 minutes.
7?
Oh, you're the new timer. Great, thank
I'm the
you.
new Pamela. A lot uglier.
Oh, you got your cell phone.
He's tougher. He'll cut you off.
I believe it. How are you?
Okay,
Ready?
ready.
Hello, Chairman Rosenbaum and distinguished commissioners. My name is Troy Dean. I'm a native Oregonian and have been happily married to my best friend for the last 25 years with 2 wonderful kids. I've owned Cascade Summit Liquor for the last 13 years. As mentioned in my previous interview, I grew up in the Portland metro area, specifically Selwood Moreland neighborhood. I was raised by a single mother who worked long hours, so when she would leave for work, I would ride my bike to my grandmother's house on 60th and Reedway, just a few blocks from Woodstock. I would spend my days riding to the Disco Mart grocery store, picking up groceries for my grandmother. She'd give me a little extra money to stop at the Arctic Circle to get a burger and fries. I also used to love Friar Tuck Chicken, which was also on Woodstock. I have many memories of this neighborhood, and I feel like I have come full circle sitting here today. I would love to have the opportunity to be part of the community and neighborhood that had such an impact on my formative years. Thank you in advance for your consideration. Woodstock, established in 1889, one of Portland's oldest neighborhoods. The name Woodstock came from Sir Walter Scott's novel of the same name. Founded in 1977, the Woodstock Neighborhood Association has improved the neighborhood in many ways, such as partnering with Friends of Trees to plant 900 trees in Woodstock and hosting numerous neighborhood events. Southeast Woodstock Boulevard is thriving with new businesses opening up in recent years. New Season, Grand Central Bakery, and the Portland Fish Market have bolstered the local food offerings in the area. Reed College also hosts an annual 3-day Ren Fair, Renaissance themed, in the spring to celebrate the completion of the students' thesis. This is also one of the busiest days of the year for Woodstock Liquor. I plan on devoting as many hours as it takes to get the store up and running to OLCC standards and satisfactions, as well as my own high standards. Excellent customer service is something I strive for and is one of my top priorities. Greeting every customer that walks in the door, making them feel welcome, and always asking if they need help or have any questions. Making it a point to thank every customer when they leave. I plan on implementing an inclusive workplace, meaning I will create a climate in which respect and positive recognition of differences are all cultivated. In my 18 years in the industry, I've never sold to a minor or a VIP. Making sure this record stays constant is another top priority. I managed Oregon City Liquor from 2000 to 2005 while they were a top 10 store in the state for total liquor sales. During the time of my ownership of Cascade Summit Liquor Store, I have doubled the overall liquor sales, added 400 new SKUs, updated the interior design, doubled the shelving space, extended hours, and opened on Sundays. I am constantly looking for new products for my store to stay on trend. This past December, I was up 10% over last year's sales. So my goal for Woodstock is to enhance customer experience and update all current retail environment, leading to an increase in traffic and overall sales. I will be looking to make this store to move this store to a better location. The leasing manager has told me he would be willing to break the lease agreement if I am able to find a suitable location that meets OLCC's needs as well as my own. I will be working closely with OLCC throughout the entire process. Until that time, I will move forward with the renovations of the current building, featuring a local spirits and dietary restriction sections, new updated security system. I will also be putting a multimedia marketing to advertise products, tasting events, monthly specials, recipes of the month, and letting customers know about upcoming events in the community. Updating the exterior of the building with fresh paint, eye-catching sign, and adding our own mural with a fitting quote to make people stop and take pictures and tag our business. This will both benefit community and business. For the interior of the building, I will expand the floor space by 625 feet by pushing back the back wall to allow for more shelving and cooler space, for also adding beer and wine. The new interior paint, update shelving, polished concrete floor, and all fixtures updated to a modern look, including my desk, counters. As well, I will also include diversity and inclusion training annually. My forecast for sales for 2019 is 10% growth. Woodstock sales have been trending upward for the past 5 years. I believe I can expand the growth of the store by implementing all the changes as I mentioned below. We'll also have a new logo, eco-friendly bags, and company shirts so all staff is easily identified by customers. A re-grand opening launch and community involvement. My team will also have updated training on customer service expectation, responsible selling, training in acceptable ID identifiers, underage sales, VIPs, and product knowledge. Thank you for taking the time out of your day to learn more why I feel I am the best choice to become the new owner of Woodstock Liquor. Thank you very much.
Thank you.
Thank you.
Thank you.
Any questions? Were you in front of us recently?
Yeah, I was in
thought
front
so.
of you for the Beaumont store.
I thought so. Thank you so much. One question to you, Brian, have nothing to do with this presentation. What is the criteria? I should have asked this a long time ago. What's the criteria for financing? What do you look for in terms of the ability to finance a store?
Chair Rosenbaum, Commissioners, the ability to finance, excuse me, is a mixture. The resignation buyout, if you're resign, retire, you've built up a business, the buyout amount. What we do is we also do an independent appraisal for the fixtures and equipment associated with just spirits in store. And then in the information sheet, when we advertise for what it takes to be able to qualify financially, which is in our information sheet, is published. So you have to prove that you have the financial ability to go into this acquisition.
What's that criteria? What's the minimum amount?
In this particular store, because they
Yeah,
change.
well, let's look at this particular store, although I'm more interested in the overall concept.
So the total, now I'm lost. You got me off guard. 170,000 to 178. The reason we include the lease one, the utilities, those are all an estimate based on average expenses that we've seen, including payroll. The reason why it's over the buyout, which is 93,000 plus fixtures and equipment, is most of it, we estimate 2 months before we give you a check from OLCC. It's never usually that long, but that's an estimate so that you can prove that you can pay all your bills, your employees, and continue with the operation.
So if somebody has 170,000 and somebody has 650,000, it really makes no difference as long as you know that they've got that minimum there, right?
That is correct.
Okay.
That's absolutely correct.
That's good to know.
Thank you.
Thank you.
Thank you very much.
Okay, under your second one, we're going to bring up Holly Hassan.
Thank you.
Chair Rosenbaum, just for quickly, it varies every single one based on the
Right.
store and fixture and lease and everything, so hopefully that helps.
Yeah, it does. It does.
Thank you.
Thank you.
Chair?
Yes.
Hey, Brian, I failed to ask, so is it possible that the candidates can tell us if they're gonna retain their current store?
Yes, it is in the materials, but yes, they can. So Troy, I'll answer on behalf of him. He is intending to operate as a second store. So for those of you in the audience, if you're currently a liquor agent, just disclose that in your presentation.
Okay. Good morning, Chair Rosenbaum,
Good morning.
Director Marks, and Commissioner Melitas, Curran, Harper, and Wall. First, I want to thank you for the opportunity to present for my proposal for Woodstock Liquor. For those of you who don't know me, my name is Holly Haas, and I've been the agent for store 1243 Bethany Liquor for 6 years, as well as an active board member of the Associated Liquor Stores of Oregon. This is my husband, Ash, who is my right-hand operation person, and one of our daughters is here with us today, Seema, sitting here, home from college for a few days. Today I want to tell you about myself, my experience, and my vision for Woodstock Liquor. Together, Ash and I bring over 40 years in retail and management experience. Throughout both of our careers, We have prided ourselves on our commitment to customer service and enhancing the customer experience. Both of these elements have been key to our success at Bethany. Simply put, we know our customers and continually strive to meet their needs, as shown by the reviews on page 3. This commitment to customer service has translated into increased sales. By extending the store hours and increasing product selection, we were able to increase our total sales exceeding sales forecast from $1.7 million when we took over the store in 2013 to $2.8 million in 2018, and licensee sales from $26,000 to $120,000 as indicated on page 2. And mind you, Bethany has a small footprint with a small sales floor of only 875 square feet. In 2016, we were given an exclusive store award for top 5 comp sales gain of 10.57%. We have also been recognized by Mr. Fleming's team as being in the top 3 in Oregon for Scotch sales. Over the past 6 years, we have created a solid and very reliant team at Bethany and have also forged a strong relationship with the community. As indicated in the Bethany Living Magazine article on page 18 and 19, having built our business and reputation, we feel confident in delegating the daily operations of Bethany to our manager, Mr. Louis Pineda, allowing Ash and I to focus on developing the business at Woodstock. The use of mobile security apps and GoToMyPC will give us remote access to both stores. Woodstock is located less than 15 minutes away from our home, allowing us to be heavily involved in the business. Being so close, we are familiar with the area. The demographics on page 5 show that Woodstock is a growing community. According to the 2012-2016 census, the overall population was over 9,000. In fact, some other reports say that it has already grown closer to 11,000 and is expected to grow another 20% by 2025. 60% of households have an annual income of $70,000 to $200,000. The consumer base is well educated, and like at Bethany, we want to actively engage with this community and meet their needs. We plan to maintain the current staff at Woodstock because they are familiar with the neighborhood and the customer base, and we also plan to offer health and time benefits to them as we offer our team at Bethany. Our main goals are to make Woodstock a non-exclusive store by introducing beer and wine, and for the convenience of the community, increasing the store hours by 18 hours a week as outlined on page 4, which would in turn help us to achieve a 5% sales increase as a conservative target. By increasing the number of SKUs offered, we will be able to increase our selection of exclusive scotches, bourbons, rums, and gins, and will hold weekly tastings to increase customers' product awareness, which would also help us increase sales. We will create a website, which Woodstock currently does not have. There we will post our hours, new products, recipes, and we will also use social media like Facebook, Twitter, and Instagram to increase our reach and provide customers with more information about the above-mentioned items. Our plans to modernize the store are outlined on page 7 through 13. We will create a new sign and place posters on the windows to catch the customers' eyes as they walk or drive by in the neighborhood. Our proposed layout on page 8 shows that we plan to increase the sales floor from 1,000 square feet to 1,500 square feet and decrease the stock room to about 600 square feet. We will make the sales floor easy to navigate by increasing gondola shelving, new signage, and lighting to highlight the products. We also plan to replace the carpet with polished concrete and put a fresh coat of paint on the walls. The budget for these changes is outlined on page 14. As we all know, there's a plan to rebuild the building, and based on our conversations that we had with the current landlord, it is our understanding that we will be expected to honor the 3-year lease. Within 2 to 3 years, there's a possibility that that building will be demolished and rebuilt. The current landlord has expressed a willingness to work with the Woodstock agent during this period, and so with this in mind, Many of the changes proposed can easily be transferred to another location. In closing, I'd like you to know we're both passionate about retail and the spirit industry, want to take our experience to the next level, and would like to create a legacy to pass down to our college-aged daughters who have been actively involved in our business, helping us with the social media. If appointed, we are confident that we can use our retail knowledge and our experience at Bethany to give customers the best possible shopping experience at Woodstock and increase the annual sales. Finally, you will find letters of recommendation on pages 16 through 18. I thank you very much for your time and consideration, and if you have any questions, Ash and I would be happy to answer them.
Any questions? I have one. I was impressed that you, in your Bethany store, you increased your licensee sales from 26 to 120,000 from 2013 to now. One, just give me a brief understanding of how you did that, and two, how important is that for the new store if you get into it?
Well, in Bethany, you may not be familiar with where Bethany is. It's a small neighborhood it's just one complex. There's like no other complexes around there, and it's just housing districts all around. And we have new housing districts coming in the neighborhood, so that our business is, increasing from that also. But how we've increased our sales, I believe, with the licensee sales is that as businesses come into, a neighborhood, our neighborhood, I can't even think of the word. Geography, thank you very much. We, introduce ourselves and offer them service, and we do deliveries. We try to take very good care of our customers because they are just as much a customer as the people that come to our counter. So taking care of them is just as important as taking care of the counter customer, and we do our best to take very good care of them.
Okay, thank you.
You're welcome.
Okay.
Thank you.
Good, so under that, we'll go to our third applicant. This is under Cocktails, Inc., Jeff Robertson Jr.
Brian.
Thank you.
Director Fleming, it has here, is there a Jeff E. Robertson, a senior?
There is a senior. He actually is recovering from surgery, so he can't be here. He's the acting agent, though, at Rose City.
Okay, thank you.
He's one.
Thank
His
you.
dad is the acting agent. Brian explained it to us before. So he's like that.
Ready?
I am.
Okay.
So I am Jeff Robertson Jr., and I will be representing Cocktails, Inc. today. Thank you, Mr. Chairman and Honorable Commissioners, for allowing me to be here today to present to you. It will be a great opportunity if we get the Woodstock store for our family to add a second store. Today I'll be talking with you about what we've done at Rose City Liquor over the 19 years that we've owned it, and how those will translate into success at Woodstock. I'll also be discussing with you what our plans for Woodstock is going forward and how we see it going into the future to be a successful store and hopefully be able to reach the sales goals that we have for it. About our team, we have 85 years of experience between the 4 family members that will be assisting and running it. 51 of those have been spent in ownership or 51 years of management or ownership. 38.5 have been spent in running an Oregon liquor store retail store. Jeff Robertson Sr., my dad, has been the agent since 1999, and he and my mom actually used to both own liquor stores. They had Menlo Park from 2001 through 2008 and have relocated 2 of those stores, both Rose City and Menlo Park, during his time as agent. Myself and my wife are also part of this process, and I personally have been involved in 2 of the relocations, and my wife has been involved in 1. Pages 3 through 6, there's a little bit more in-depth bios about each one of us. The way that we'll manage 2 stores is we'll have 2 family members at each store. We'll use GoToMyPC. We'll have video surveillance where you can use your laptop, your cell phone, or whatever to be able to access it remotely. The 2 stores are 21 minutes apart from each other, so in case of an emergency, we are able to get over there pretty quickly. I also live 5 minutes from there in case there's something that happens overnight, to be able to get there really, really quick. Going on to page 8 through 10 is a little bit about Rose City. There's a picture of what Rose City looked like when we first got it in 1999 and what it looks like today after we had a store built for us in 2011. In 2016, we went through the process of converting from a exclusive store to a non-exclusive store and added 700 beer and wine items, and also increased our distilled spirits by 300, bringing the total to roughly 2,300 of what we offer today. During that time of 2012 to 2018 fiscal years, we have added 2.81 million in annual sales. We have also been one of 3 stores to rank top 10 in both consumer and retail or licensee sales for 2017, 2018. And we also had an average annual sales during that time of 7.41%. So what we've been doing has been working, at least at Rose City. Going through pages 11 through 14 is the current store and what we propose to do to the current location. As you see, half the store right now is sales floor and back room. And the sales have increased 1.5% average over the during that same time frame of 2012 to 2018, and has added 274,000 in annual sales during the time that we added 2.81 million. Looking at pages 16 and on is what we plan to do for Woodstock going forward. Troy already mentioned the neighborhood history that I was going to read to you. But the point I wanted to point out was what Woodstock means, and it's a place that's fortified by wooden posts, and that's why each slide has a little bit of a wooden post down at the bottom. Going forward, we want to include that into the store, have a little bit of the neighborhood within the store. At the current location, we plan on increasing the sales floor by moving the divider wall back 20 to 25 feet. That will add about it'll make it so we have about 900 linear feet of shelving. We're going to remove the carpet, do the polished floors that other people mentioned, install 2 gondolas, paint and replace, do a deep cleaning on it, replace some of the lighting in the back. It will allow us to have about 2,000 to 2,200 distilled spirits along with beer and wine. Other changes that we are going to make is converting, as I just mentioned, converting to non-exclusive, developing a new store logo so we can rebrand it and start using social media such as Instagram, Twitter, and Facebook to start highlighting new items that we're bringing in, along with drink ideas that customers can use for those new items. We're going to create a website to help customers be able to find us and figure out what we have, what items are going on sale in the future. And we're also going to use an app called Drizzly that will allow customers to go on, see what beer and wine we carry, and have it delivered to their homes within a 5-mile radius. We currently use that at Rose City Liquor, and it works great. We're going to change the store hours from Monday to Sunday, or Monday through Saturday from 9 a.m. to 9 p.m. and open on Sundays from 11 to 8. We're going to focus on increasing the bourbon, the vermouth, the amaros, gin, tequila, and mezcal, stuff that the cocktail industry is going crazy for and the cocktail boom is searching out. We're going to focus on craft of beer and wine along with Oregon spirits, cherries, bitters, other stuff for cocktailing. We're going to be involved in the community. Currently at Rose City Liquor, we sponsor or donate to several charities. The picture on page 18 is one of the displays that we worked with on Jim Beam over the holidays, and it was a Toys for Tots display where customers could come in and donate to have a Toys for Tots donation site. Our timeline of the fixtures at the current store are 6 months. We plan on having everything revamped at that location by then. But all these changes are temporary. As the other presenters mentioned, there's 3 years, and then you have to move. So we're currently working with 3 realtors. You can find their names right there on trying to find what our requirements are, which can be found on page 21. We are going to be looking for a spot that's 3,500 square feet or larger. The new site must have parking for customers.
Thank you.
Yep. Is that time or 1 minute?
That's time.
Wrap it up.
Okay. Yes, and we want to have one of the largest selections possible when we get to the new location.
Thank you. Chairman, I had to take a call. Are there any questions for any of the commissioners?
Real quick one, Drizzly, you're just doing the beer and wine, not.
Yeah, Oregon law or Oregon rules, you can't do the distilled spirits yet. I know you guys had discussions about doing that in the future possibly, but right now we just do the beer and wine.
And you use your own vehicles to deliver that?
Yes, and what it has is it's actually, so it's Drizzly's the platform, and it has a way that you can scan the ID to make sure that they are 21. We use our own deliveries. The customer just goes on to that app. They can see what we have, and it's actually, they can do next day delivery if it's a larger order, so that way it goes with the Oregon rules on the quantity. And then if it's within that quantity, they're actually able to do within an hour, between certain hours.
Very cool, thank you.
Yeah.
You know, a final question. You're a pretty sharp guy.
Thank you.
And well, it's true. But you're encased in this corporation. Have you ever considered making an appeal for your own store outside of the family corporation?
Yes, I'm just not the one that has the money. So my dad, he's been the agent, so he's the one that has the money. So kind of doing that rather than taking a loan from him, having him involved.
All right, and plus I appreciate any man that buys lottery tickets. So thanks for being on your paperwork.
Yeah.
All right, thank you. Thank you very much.
Yep.
Thank you. Okay, we are under G&G Sicaria. And this is gold. And Commissioner Harper, this would be operated as a second store, and it's in the materials as well. No, the former.
I didn't see that paperwork on the first one.
Thank you.
Is there one for?
No.
Oh,
Yeah,
Chair?
it's right there.
Ready?
I am.
See, I'm not Pamela. I'll just let the bell ring.
And state your name for the record.
Hi, my name's Gold Sicaria. Just to introduce myself, thank you for your time today. Just to want to introduce myself, my name is Gold Sicaria, and I've been into the beverage industry for a while. Not the liquor part, but the beer and wine sales. Been working at a convenience store since I was 13 years old as a family business. Left and decided to pursue our bigger passions, go to college, and decided to pursue even a higher education after that, get my MBA. After that, I decided to become a sales rep for a pharmaceutical sales agency. The reason I'm bringing all this up is because I think it is very connected to being a liquor agent, because you have to sell the liquor to either a B2B or B2C. So although I don't have any liquor experience, I do have a lot of sales experience as well as managing experience. After I left the pharma agency, I ended up owning Subway restaurants. I started off with 1 in 2015 and expanded to 2 in 2016, and just this year I expanded to 4. So what Subway really brought to the table for me was able to inventory management, deal with employees, deal with payroll. It kind of gave me the gist of how to run a business by myself. I am a sole owner of these corporate of G&G Sicaria, and I will be running this by myself. The benefit of having me for this location would be my family is retiring, so I will have my sister and my family members helping me out on this one, so I won't have to run this solo. What I plan on making changes for this location is actually making this from an exclusive store to a non-exclusive store, adding beer and wine, adding lottery. Those are currently right there, but expand the selection of that. And also, one thing that I saw that's getting pretty popular, especially amongst the younger demographics, is a growler station. I feel like that would add value to, especially that location, because it is right next to Reed College, and it is something that people typically go in and want, and also get other selections like beer, wine, and liquor. So it adds value to the location. Anything that I put into this location, I have to be cognizant of the fact that it will be moving in 2 to 3 years. So whether it's upgrading fixtures like everyone mentioned, moving the wall back for expanded selection, you want to make changes that you could take away from and move to another location. So the fixtures are movable, the growler station, all the expansion will be just temporary into getting a new location. I also have experience in relocating locations. Out of the 4 Subway restaurants I've had, I had to relocate 2 of them. So I understand the leasing requirements, buying or purchasing the land, and understanding that the sales that we have today is going to change when it comes to relocating. So just because you have a $3 million store right now might not be the case 3 years from now. So you have to estimate the cost and the future sales of that too. So the reason I bring that up is because I want to focus on the B2B location. It's about 500,000 right now. It's a very an area that needs to be expanded, because you could transfer that to your new location as well. So the B2C customers are always going to be there as long as you market and market that properly. And the B2C customers you could take over from one to a location. I do have all these Subway locations that have bars and restaurants around, and have an opportunity to expand through those locations. What I plan on doing with the current location is expanding the hours immediately, adding 2 hours on Friday and Saturday, and expanding an extra hour on Sunday. That will give more awareness to the area, let people know that there's a new owner, new management involved in the operations, and draw more customers that way too. The first year of expansion, I want to get involved with the local community, whether it's Reed College or just the area in general, trying to build awareness so I know that what areas are up and coming. There is a new seasons, new businesses that are opening up everywhere, and you want to know what possibilities there is to expand, especially if you're planning on getting another location, or relocating the location. Right now, the location is 2,500 square feet, and the goal is to get something around 3,500 square feet of location, because you want to have enough inventory and enough space to expand your product, especially if you're going to convert it into a non-exclusive liquor store. The other aspect that I want to expand on is the social media part. Because you are going to be relocating this location in about 3 years, you want to have a strong social media presence. Since it's located next to Reed College, there's going to be a younger demographic, and you want to target the millennial crowd, whether it's through Facebook, Instagram, Twitter. The reason that's why it's so beneficial, the youth typically uses the internet for up-to-date information, whether you want to let them know about what the changes are happening with the liquor, or whether you're planning on relocating within the first year or the 2 year. So that way they're not just caught off guard when the store isn't there, or when you're planning on moving. You want to retain the customers you have, but you also want to let the new customers know that you're either moving or expanding. And because the area constantly changes, there's going to be younger demographic every year. As college students leave, they end up getting new ones. So you have a large room to grow as well. The expansion for 3 years, obviously, relocate the property, possibly buy out the property if the owner is willing to sell, which he wasn't opposed to the idea, but he is planning on demolishing the building right now. Upgrade all the fixtures, like I mentioned. Keep constant with my first year goals, and even in year 3, because even though it's startup, you always want to run a business as if it's a startup, because you want to dedicate your time and effort into that business and expand as much as possible every year throughout the year. Portland's one of the highest growth cities right now. On average, it grows 1.8%. Obviously, the last couple of years, it's been a bit lower, so it is that area and Woodstock in general has even a higher growth because it's constantly changing with new business and buildings. Other than that, the goal is, like I said, focus on social media, increase the business-to-business sales, and plan on relocating in the next 3 to 5 years. And that's it.
Chair Rosenbaum,
Commissioner?
do you still own the subway stores?
I do.
How many?
4.
4? So you have 4 companies, and you're waiting for mom and dad to retire to come help you? No.
Well, 2 to 4 was.
Tell me how you're going to run 4 stores, 4 franchises, and have time for this.
So the Subway franchise, the great thing about everything is cost controlled, and it's very easy to expand because everything is monitored and very minimal involvement. It's very employee driven. So that's why they say if you get into a franchise, it's very easy to go from 1 to 2, 2 to 4. That being said, you have to show that you're expanding and growing the location or they don't give it to you. The reason why I wanted to go to the OLC, I've been applying for a couple times, so hopefully one of these times I'll get it. But I wanted an opportunity. I just got married last year, so I'll have a wife this time around, so I'm not running everything solo. I have a sister that goes to OHSU, and I have parents that are retired. Not for the fact that I want them to work there, but their expertise, their knowledge. They've been working at a convenience store, owning a convenience store for 25 years, and always want to have insight from family. They instill that work ethic in me, so I just want to kind of get their expertise. So whenever I do have a problem, I have someone to lean against. And since we are changing from exclusive to non-exclusive, their expertise will help me with the non-exclusive aspect part of it. And just always extra hands when it's remodeling time, relocating time. It's always good to have that.
Thank you.
I'm just curious, in your co-managing of the Chinese startup company, was that in China?
Oh, that was in China, right? So in our,
how long did you spend there?
We spend truthfully, that was an MBA project. We go to China, we build a business, and so we were there for a month. The goal was to establish a business in China and see if it was profitable. We learned early on with most of the companies that it's not, because it's the government. They could take it anytime they want, so it's kind of pointless to invest in something like that. Even though it was a profitable business over there, it's just the political environment. You can't really.
Do you understand the global markets as a result of that?
I do, yeah. So it was very interesting in China, so that's why I'm hoping, in Oregon, and it's beneficial too.
I'd like to say that you're the type of business owner with the past experience to be very successful in our industry. And I just wanted to take note that you're the first in my experience here at the commission that had in skills, you wrote languages, you can speak 3 languages, you understand operating systems, Mac, OS 10.9, Windows, ISO, and Android, and you know software, Word, Excel, PowerPoint, Outlook, and Photoshop, and that's more than me. So I'm proud that I'm not going to go learn about this stuff, but it's nice to see, and I think that's where the way we're going here in regards to not only marketing, but also being able to communicate to your potential customers. So congratulations.
Thank you very much.
I really liked your presentation.
Thank you.
Okay, Commissioners, I have one final. Philip Yee will be the final applicant for this store. Thank you.
Thank you.
Thank you.
Remember to state your name for the record, Mr. Gaines.
Ready?
Yes. He's serious about the time.
It's a heart attack.
Thank you today, Chairman, Commissioners. My name is Philip Brandon Yee. I go by Brandon. I am applying for the Woodstock Liquor Store. I'll be going over my background, my objectives, demographics of the Woodstock area, basic store financials, and business plan A and B. My background, I'm a born and raised Oregonian. I was raised in Gladstone, until I went to Oregon State, where I graduated with a BS in communications. I met my wife there freshman year. We've been married for 12 years, and we have 2 energetic, fun children, Ella and Cole. My business background is pretty much out of college. I started working for Bella Furnishings, a retail store, furniture store. Started doing deliveries, working the floor, and then slowly moved into management. And then in 2011, I bought the store. So I pretty much can do all facets of a retail furniture store: inventory control, invoicing, payroll, utilities, warehousing, sales, customer service, marketing, advertising, and manufacturing relations. Last July, we moved the store. We've been there for 14 years, so I had to orchestrate a 12,000 square foot furniture store into a 10,000 square foot new location. So I know what it will take to move the Woodstock store in the future. My objectives are basically to, like everybody stated, it's pretty much going to be a big ditto. Shopping experience. I think liquor stores are a unique retail atmosphere, whereas you don't have any competitive on price. Everybody sells the same thing for the same exact price. So how do you win the customer over? You do it by customer service, experience. So I think that store just needs serious revamping, kind of create a better selection, offer better customer service, and then safety to the customer and the staff. I think by doing these, we'll have increased sales. And I also want to be involved with that community. I think the Woodstock area is a very tight-knit area. So, where am I here? Shopping experience, selection. We're going to go, pretty much like everybody said, I don't think I'm going to expand. My plan was to expand it as much as everybody else with just moving the back wall about 10 feet, which gives you about 240 square feet more. That we can bring in more specialty whiskeys, tequilas, mezcals, gins, and local varieties. The goal would be to go non-exclusive, so bring in beer and some wine. I know there's a very large wine store just a couple blocks away, so it'd be hard to kind of compete with what they have, but at least try to make it more of a one-stop shop for the consumer. I'll do my best to make sure that the staff and myself are trained in the most up-to-date procedures and protocols for state regulations for selling beer, wine, and spirits. In the refresh of this current location, I plan to have a better traffic flow for customer safety and staff safety. Just make sure that you have a good flow around the counter and then the entrance. And I will update the surveillance system and the point of sale system for safety, inventory control, and off-site monitoring. Try to increase the sales through all of what we just talked about. The greater selection, updating the interior and exterior. Plan on having a 2-pronged marketing campaign of grassroots and then online. And then training the staff on being up to date on all the product that we plan on bringing in. Community involvement. Join the Woodstock Community Business Association. Trying to be active in the Woodstock Neighborhood Association. Then slowly, after kind of get the foundation of the store, kind of expanding in the surrounding areas. And then also maybe setting up a booth at their farmer's market. I know they have 4 distillers that show at that farmer's market, so maybe if they don't allow me in there, then working with those distillers to kind of, have some sort of collaborative idea there. Like people have said before, the demographics for the Woodstock area, it is slightly outpaced the state average for growth, but it is a very diverse neighborhood. I'd say it has all walks of life, from low income to high income. And then 80% of the population is of age, so there is a majority of the population could be a potential customer. The store financials, like people have said, the last 5 years has slow increase about 1 to 3% year over year. Just a slightly slower growth than some other stores I compared it to. It didn't have a dip in 2017 like some stores I compared it to, so it was consistent even though it hasn't had any money put into the store for the last few years. So the low overhead of the current lease structure would also help with the flexibility of building out and making that spot nice. And I did compare Moreland and Tigard, which went through something similar to what we would do for Woodstock, where they kind of brought it in, refreshed it, and they saw 11 to 15% growth. For the business plan A is for its current location. So between the first 3 months, it's just myself getting up to speed. I don't have any experience in retail spirits, so I'd have to kind of learn their procedures and systems, get up to training, gauge the quality of the staff, and kind of see where their weaknesses are, where their strengths, and try to learn from them. And then also work with the current landlord to explore any options as far as early termination in case a good location did come up that we could move the store to. And then figuring out traffic patterns of when their busy times are for staffing, efficiency, and then adding a suggestion box so people can give us feedback on what we might need to do. For the 1-year term for that current location would be to start the renovations. Like others have said, remove the carpet, polish the concrete floors, new flooring if it's required, order new shelving. If you look at page 15, it's kind of like a basic layout of what I would think would work there. Remove all there's pegboard on the walls, there's horrible lighting in the ceiling, so replacing with LED lighting. And then, like I said before, pushing back the back wall 10 feet to increase storeroom space. And then also put racking in the back. There's currently no racking or shelving in the back room. It's just all boxes on the ground. So that's on page 16. So create racking in there so there's efficiency and organization.
Thank you.
Really?
It goes fast.
I thought it was gonna be fast. It was like, okay.
Chair?
Commissioner?
I just one question. How, and I'm gonna ask you because you have the least experience of any of the people we heard before. I'm gonna sort of test you.
Okay.
How many times did you talk to the prior owner before you came to sit in front of us? And what was his advice to you?
I think it was 3 times. His advice was to pretty much have a good plan, and didn't give me a bunch of feedback, but it was basically, just work it. Kind of something that he said that he wasn't really actively doing. It was just, the store just needs some attention and some love. So pretty much.
And then what does work it mean?
Like actually be there. Like treat it like you're not just complacent. I know that happens with a lot of owners. You get owner complacency and you just kind of you're happy. You're content with like the protocol. So it's not having that, and it's being reinvested, being excited about it, like having a love for what you're doing, and just pride of ownership.
Okay, and if you were awarded this business, would you be willing to learn more about the products that you sell, whiskey, gin,
Oh,
the
for sure.
origin?
That's part of the fun, right?
I don't know what work it means, but
I always do that.
Yeah.
you work it?
No, you don't work.
Oh. And the reason why I ask it is because this is a serious practice, and I just want to make sure what you've done with your furniture store is just phenomenal. So congratulations, and I hope when you went into that furniture business, you said you just want to work at that first day, and you've done a great job. So congratulations.
Thank you. Yeah, it's I have friends and associates that own liquor stores, and said that they would help me in some capacity to kind of with the transition and kind of get me up to speed. And I think knowing the business, it's fun to do the research on it.
Yeah.
So it's always good to be passionate for your business,
Okay.
your product.
Right, and one of the things that you heard a prior current agent say is that she said she would retain the current staff. Would you do the same?
Oh, I'm not rocking the boat. Not coming in with no experience. I don't want to be just left there. So I'm gonna go in there, and I was like, give them pay raises, just like make sure everybody's happy, and then learn, and then see who's not the right fit. Because I've heard that there was a transition recently, and they lost all their staff. And if that happened to me, it would, be very difficult to kind of have that transition. So I needed to be as smooth as possible. And talking to Bob, he said that Monica's been very faithful. She's been there for 16 years, and I don't see any reason to rock that boat unless it's just, we
Okay,
don't move on or
I'm sort of
something
hearing. I'm
happens.
hearing you now. What work it means. So
Yeah.
there you go.
Yeah.
All right, thank you.
Yeah, thank you.
Brian, 2 quick questions. One, what do we have, 290 stores now, roughly?
No, Chair Rosenbaum, so we did open 3 in parts of December, So we're at 276 today, headed to 284.
Okay, so out of the 284, well, out of the 276, how many are exclusive stores?
So the remaining, so I'm gonna go back a ways because I don't have it in front of me, and I can certainly get you that. When I started here, it was 150 exclusive, 94 non-exclusive. It's completely flipped.
And-
So the balance is way higher on the non-exclusive converted
Do you see
stores.
any way in the world that's not gonna be 100% non-exclusive in the future?
Chair Rosenbaum, at some point, I think through attrition, everybody's seen the model of one-stop shop convenience, beer, wine, spirits, glassware, Coke, ice, builds the entirety of the business. So I'm not gonna say it's gonna happen overnight, but through, as
Yeah,
we develop and go
it's
forward.
a clear trend.
Absolutely a clear trend and clear growth for us because the beer wine actually they come in for a destination, which is spirits monopoly, and they're selling the other. And as you develop that beer business, they come for beer or wine, and then you sell a spirit. So it's been widely successful.
Okay. The other question is there any prohibition against liquor advertising on buildings or anything else?
Chair Rosenbaum, we went through a extensive review of the advertising rules with our DOJ counsel, and it's because of so much speech, it's pretty wide open. We ended up in an opening with a billboard along a freeway announcing the store, so it's pretty progressive in terms of advertising.
Nothing on the
media.
statutes that would prevent anybody from putting a huge sign on a building or anything else?
Not to this time, no.
Yeah.
I mean, it's way more wide open in terms of advertising from what it used to be 10, 20 years ago.
Yeah, I just a matter of a comment, the first presentation, he had a Jack Daniels on the building, which, I thought was very attractive, but I also wanted to know whether there's any prohibitions against that.
Well, there aren't prohibitions as it relates to federal financial assistance rules and the idea that a manufacturer supplier would put that on there. It would have to come at all costs to the individual.
I'm a gin man.
Okay, the commission will now go into executive session to deliberate on the agent selection pursuant to the authority of ORS 192.660 sub 2 sub A. If there are members of the media present, representatives of the news media, and designated. Can I have your attention? I'm not done with this, and I need to say this. If there are members of the media present, representative of the news media and designated staff shall be allowed to attend the executive session. Representatives of the media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. No decisions may be made in executive session. We'll return to open session in this room. Now you can go do. You have it, Joe?
Yeah, here it is. You got your book?
Sales, I know, but it's.
Corporate name.
We're back in session. I just want to make one comment before Commissioner Curran makes the motion. We've been doing this for close to a year, and we've had a lot of them come in here. And this particular exercise on voting for us, any one of the five, seriously, are excellent candidates. We were impressed with all five. And I haven't said that before. And there's a unanimous consent by the commission that all of you did excellent. And unfortunately, we can only pick one. I would highly recommend that when new positions come, you apply again for it, because you left us with a very favorable opinion. Now, I haven't said that before, but we really do mean it. So with that, Commissioner Curran?
All right. I move to appoint Troy A. Dean as the permanent agent of store number 1215 Portland Woodstock, effective March 2019.
Commissioner Curran,
Yes.
Commissioner Harper,
Yes.
Commissioner Melinas,
Yes.
Commissioner Revelle,
Yes.
Chair Rosenbaum.
Yes. What do we have, administration next?
Do we break and go back into room?
No.
We're doing this,
Just
then we're going to our meeting.
He's ready to come up, Chair. He's ready to come up.
We got you next? Oh, briefing, okay. Everybody's leaving. Is it you, Renee?
Pardon?
Thank you very much.
Thanks, Howard.
You know, it's a good decision-making process. We've been pretty damn good at this, right? That was a good decision-making process.
I think, yeah, I really like the conversation. Everybody helped to go in the right direction.
I mean, we're getting to the point now that we know pretty much where we're going. It's interesting.
Yeah.
It just takes some time, that's all. Now that everybody has left except the really important people in the room.
Mr. Chairman, before Renee starts, I just want to do something related to retail services because we did have comments on the public opposition to locations. We looked at those. Some came in after your record. I've evaluated them, and I don't believe there is anything significant about that public opposition. There was some trickiness in that, but nothing that would preclude those stores going forward. I just want to put on the record that we looked at that, and I'm accepting responsibility for the determination that it doesn't meet the threshold of significant public interest for the record.
So be it.
Good afternoon. For the record, my name is Renee Niedermeyer. I'm Director of Government Relations, and I'm going to give you a relatively short legislative briefing. We'll be having more to come. So just as an overview, the 2019 legislative session officially starts next Tuesday, but legislators are already in the Capitol. They had organizational days, swearing in, moving into their offices, getting their staffs oriented, and going to training. The session itself is targeted to run about 4.5 months. The target sine die, the end of session, is the 21st of June. However, they're required constitutionally to end by June 30th, Sunday, June 30th. Even though it's a longer session, this session's long every other year, it's a long session. It's still relatively fast-paced. The first slate of bills were dropped on the Oregon Legislative Information System last Thursday. There were about 900 bills that were dropped, so we're busily reading through hundreds of pages of potential legislation. We're tracking in the agency about 50 different subjects, and the bills that impact OLCC could land in one of 20 committees. So we're going to be pretty busy down in the Capitol. The other thing that's a little different this year is we have some new chairs and members on the committees that typically work with our bills. So we're going to be doing a lot of foundational education about our agency and what we do and how we can help them answer questions that they might have. So there's going to be, we've already started that work, and we'll, that's the first part of session. We're going to be doing a lot of that. There are 4 primary areas impacting OLCC that you're going to be hearing about. Alcohol and alcohol realm, where you've already heard about wine labels. That's going to be a big topic down in the legislature. You're going to be hearing some revenue issues, the 5% markup on distilled spirits, increasing beer and wine taxes, doubling alcohol fees, and you're also going to be hearing potentially about agent and distiller compensation. So we'll be having more conversations about that. On the marijuana subject area, you're going to be hearing about demand versus supply. Yeah, there may be discussions on caps or moratoriums or other alternatives to address those issues. You're going to hear about medical marijuana and access for cardholders and options for public consumption, maybe public consumption at temporary events or in indoor or outdoor venues. So that discussion we expect to see moving forward in the legislature as well. The bottle bill is going to get a little more action this session. We expect there's about 9 bills, I think, that impact the bottle bill. And those discussions are really focused mostly on the capacity of small stores to store the returned bottles and how fast the collections or the pickup for those recycled materials are happening. So there'll be more discussion about that. There's also maybe discussion about should there be exemptions to the bottle bill. So those you'll be hearing more about that. We will be reporting to you on a regular basis. I don't want to overwhelm you with information, but I want to give you enough information so that you're well informed, and obviously I'm happy to help you with any questions and be calling on some of you to go down to the session and maybe help us out. And so I want to make sure you know when we're having committees and what's going on down there. I did send, Laura sent earlier a legislative session bill outline. I just wanted to talk about that just a little bit and what you might expect coming forward. It's divided between alcohol issues, marijuana issues, bottle bill issues, and other legislation that's coming forward. There'll be a bill number, there's subject areas, and I put the relating to clause on there because many of these bills, what's in them right now are not necessarily what's going to be in them at the end of the session. A bill may be worked and it could have up to 45, 50 amendments. It could have a completely different bill put in that bill if it has a relating to clause that works for a new concept. So it's an ever-moving, ever-changing environment. It's pretty fast-paced. There are short notices, and we'll do the best we can to keep you informed of what's coming forward, particularly on those things that are going to change processes within this agency, have impacts on our IT, and those sorts of things. On the budget, that's going to be a key priority for us during this session. Funds for both marijuana and alcohol staff, and particularly IT staff and IT funding. So that's something that we're going to be spending an extraordinary amount of time working with legislators on this session. By our next meeting, I'll have, in between, more of an idea of which bills are actually where they're going to go in committees, and you'll be able to have that information, and which bills might be moving and which ones maybe aren't moving quite so fast. So we'll stay tuned on that. We have our first invitation to present to a committee. It's the House Economic Development Committee. It's going to be on the 30th from 1 to 2:45, and it's in Hearing Room D, and it's on marijuana. And This is a committee with a new chair, several new members, and many members who don't have a lot of background in marijuana. So this is going to be an informational system meeting for them, along with OHA and the Oregon Cannabis Commission and the League of Oregon, not League of Oregon, the Association of Oregon Counties. And so working closely with that committee to get that set up for them as well.
Any questions? Go ahead.
Sorry, just one. You sent over is great. This is a link to the bill tracker, correct, on top?
Yes,
okay.
yes. So I did want to mention on the Oregon Legislative Information System, it's really easy to track bills, and you can actually get notice of bills directly to your email, and if you want to track them. So I put a link in here because you can go in there, you could search for a bill, and it will tell you where that bill is in the process, what committees it's in, what kind of action's been taken. And then when you go on to that site as well, you can see any amendments, any testimony that's been on that bill. So it's a really good resource for tracking particular pieces of legislation.
Any other questions? Two things that I want to just say. We would never interfere with your wonderful ability to deal with the legislature between Steve and you. I know that's all covered. My suggestion to you is that if you feel that any one of the commission members would add something to the discussions at the legislature, I think I talk for everybody. Please invite us, because quite frankly, we've got a level of sophistication and intelligence that we can help. So I don't know how much you've done it in the past, but at least it's your discretion, both of you. And once in a while, it might be a smart idea to invite some of us down with you, to some of it. And if we can make it, fine. If we can't, that's fine too. But I think the commission agrees with me that that would be helpful. And Steve, just keep it in mind more than anything.
I know, absolutely. And once in a while, it's not fine if you don't show up. We need you. So,
Well, but it's up to you to tell us when and how and what benefit that we can have on it. I got two very quick things. Senate Bill 420, I'm particularly interested in whether or not that has any chance of passing. That's the one expungement of criminal record for previous marijuana offenses.
Chair Rosenblatt.
Just your opinion. We won't hold you to it. You're not a stockbroker. We won't hold you to it.
Rosenblatt. So Chair Rosenbaum, members of the committee, there's been considerable conversations about this in the past, and legislators have passed legislation in the past to take away some of the records and things here. So there may be sentiment, but I don't yet have a feel for this particular legislative body.
Okay, when you do, I'm curious on that one. The
Definitely.
other one that I'm sure is not going anywhere is Senate Bill 582, which authorized the governor to enter into agreements with adjacent states. There's a federal law that says you can't do it, so why would the governor want to do something like that? Why would they even present it? But that's neither here nor there.
Well, Chair Rosenbaum, members of the committee, any legislator can introduce a bill. And this is a subject that has been discussed before, so stay tuned.
Okay. I just wanted to get that on record. Thank you very much. And you do a great job. We really do appreciate it. Any commission feedback? Steve, you got anything you want to say? Executive Director Marks, I should say.
Excuse me. Chairman Rosenbaum, members of the committee. Not much, just want you to know we are, and it's a matter that'll come before you, but we are working very hard on the Copper King case that is with us, but also on the legislation that's come out of that associated with it. The number of wine bills that Renee just talked about is relatively new territory for us. We got, of course, a lot of the industry well known to us that's helping work through that, but that's going to be a little bit of a chore for both the legislature and us to get through with those changes. That's going to be a new area, so we're looking forward to thinking about what our authorities will be with the wine industry and over the wine industry, but it's an area that we've got to get you educated up for as we get educated, because it's not a regular part of our business in the sense that we've really done looking at labels and content and other things the legislature may or may not want us to do. So I want to spend some time on that as we go forward here.
Thank you, Chair. I'd just like to say that the end of 2018 to the beginning of 2019 has been phenomenal. We've heard the numbers from Director Fleming's in regards to sales and service, and I just like to always thank our agents out there that's doing a phenomenal job, but also the staff here at the commission. They have been stepping up to the plate. We hope that marijuana issues will be alleviated when we're able to offer licenses, but at this point, we're not there yet. But I just want to share how grateful I am to be on this commission with all of you and the great work that Executive Director Marks is doing, because we are a beacon of light for the state, and we're providing a lot of resources for the entire citizenry. So thank you so much, Chair, for giving me this platform, but more importantly, thank the staff here that's doing a great job and hasn't been beating us down lately. So thank you all left in the room, and share that with your other people with you, because we got a lot of stuff down there.
Very well put. Thank you.